Sorry, kept waiting because of that campus.
Lordship, submission, my Lordship. In this matter, my Lordship, respondent number 4 and 5, running the mining business, my Lordship. They are without following the proper rules and regulations, they are doing their business, my Lordship. For in that effect, the petitioner is suffered a lot, my Lordship. Hence, there is an urgency, my Lordship. Tomorrow, my Lordship.
21st.
Urgency is there, my Lordship. It's already listed before this single bridge, my Lordship. As this honorable single bridge bench is directed to list the matter before this honorable court, my Lordship. Hence, there is an urgency.
But what is that urgency?
They are not closing the lorries and they are not use the 10-wheelers, my Lordship. They are using the 6-wheelers and they, without closing the lorries, they are using the
21st. Yes.
Your Lordship, moving a memo for a writ appeal against the learned single judge's order. The ESCOMs are unable to correct the backdated tariffs which they have raised, which has been stopped due to an order of the learned single judge, Your Lordship.
19th.
With your Lordship's kind permission, I recommend. This is a writ appeal, fresh matter filed by the Bangalore Development Authority. Contempt is listed on 11th month. The appeal may be kindly tagged along with the contempt.
No, we'll grant time enough. Contempt. Mention it. 26th of March.
The appeal is listed. That's it.
Fresh matter, my Lordship. Immediate.
What is the urgency?
It's a challenging mandamus. It's a mandamus issued without my knowledge, my Lordship. Some third.
Will be listed. Then 3rd March, 3rd April. Yes.
First writ appeal. Last week I moved the matter, last period given date on. Meantime, there. Demolishing the compound wall and not putting up the structure. I'm in the possession of the property, my Lord. I'm saying there is some urgency.
Which authority?
Not the state of. Not the- Land was granted to our parents, same land was allotted in favor of the temple.
19th.
Early date, they put up the construction.
Demolishing or putting up?
They're demolishing the existing structure and not they're putting up the construction. At least
Well.
Monday, my Lord.
Well,
Still controlled by the connected matter, notice has been issued. It's the 3rd April. This is
3rd April. 3rd April.
Serial number 73, my lord. Last time, the lordships had directed the office to take off the objections. It has been listed for the same stage again.
73.
73, my lord. 73. 73.
73. 3520. So it's PIL. So it is listed under what office?
It was a tender document, your lordship. We need at least 45 days time to procure it from the.
It is complied with or not? Office officials are complied with, removed.
No, my lordship. I had filed a dispensing application to dispense the same, and it was your lordship had directed the office to take off the objections in the last instance, and it has been listed for the same stage again without dispensing. If your lordship grant us 45 days time, we can procure the original document and certified copy of the document and produce the same.
States that the office objections are required to be dispensed with. For this purpose, the petition may be placed before the registrar judicial, who shall examine the plea. And if the office objections are minor, the petitions will be listed after 1 week. You go to registrar judicial.
After 2 weeks, my lordship. After 2 weeks.
After 2 weeks,
my Lord,
Serial number,
as requested by Leonard.
serial number 52.
52.
I request for a week's time in this matter, my Lord. I've informed the respondent counsel. There is some inconvenience today.
It will go to 4th April.
My Lord, serial number 57, my Lord. My Lord, serial number 57. My Lord, respondent number 3 instructed me to appear in this matter, my Lord. Some time may be granted, my Lord. I'll file my objection and file my wakalatnama. I've informed petitioner counsel as well.
You are for number 3.
My Lord, number 3, my Lord.
So when do you want?
My Lord,
7th April.
please, my Lord.
Send out to 7th April at the request of learned advocate. Mr. So and so who appears for 3. And that who has taken consent of learned advocate the petitioner.
55 and 66, my lord. We've
50.
complied with the objections.
55.
54, 55 and 56.
Correct.
We've complied with the objection and filed a memo, my lord. The memo has not been put up. So if a week's time may be granted, we'll be ready for the hearing.
Learned advocate 54, 56 and
54, 55 and 56, my lord.
54, 55, 56. Learned advocate so and so stated that in all the aforesaid three matters, the office objections are complied with. In that view, the registrar shall examine the aspect of compliance and list the respective matters for admission hearing on 19th, 20th and 21st March respectively.
Much obliged.
Not your case.
Same, all three connected matters.
She must be mentioning on behalf of the.
No, no, all three.
They're
Two
different
writ
advocates.
appeals and one writ petition, my lord.
So you're wrongly mentioning 55 and 56.
54, 55 and 56. 54.12.
So 54 only to be listed on 21st March. Same order, but then. $53. 53, writ appeal number 1296 of 24. Not to be placed before the bench where one of us, interpret Honorable Mr. Justice Nemayaru, bracket is a member.
Any mention through VC, sir? The contempt matters, still number 1.
No, this matter I'm appearing for the
litigant.
complainant. Last occasion on 12/2, your lordship had permitted us to take up notice on panel counsel for BDA. my lord.
I've received
Yes.
the copy of the contempt petition, my lord. His lordship may kindly grant me 2 weeks' time. I shall secure instructions,
4th April,
please.
as requested by learned advocates for the parties. Yes, next.
Still number 2.
Lords,
For the
this,
complaint, T. Bhuvan.
this matter, my lords, we need to file review petition. We are unable to implement the order passed by this honorable court because there is dispute with respect to the possession. So we have just obtained the government order to file the review. Lordship may grant me 3 weeks' time.
2023.
Learned additional government advocate Srimati Pramodini Krishnan stated that decision is taken to file a review application in respect of the order brought under contempt. In that view, the present contempt petition shall stand deferred to 7th of April.
Obliged.
Start date may be given, my lord.
They will not,
Till today, he is waiting. Yeah, now, no other steps have been taken, my lord.
even on 7th, they will not be able to move the review petition. Therefore, longer date.
He is prolonging the matter for the last 1
No,
year.
no.
2019 representation given by the Tahsildar, my lord. From the last 7 years, he has, my client is struggled.
27th March. Right.
Still number 3. Sudhin Rai, yeah.
The complainant in this matter, my lord. The complainant is the permanent residence in the Sarli village. We filed a PIL in WP number 6848.
Notice returnable on 21st April.
Still number 4. Leela P. Devadi.
Complaint. Your lordship, they have not complied order. In the meanwhile, your lordship, they filed an appeal. That appeal is also listed at serial number 27. Your lordship may kindly, this matter may be taken up along with that, your lordship. They have preferred an appeal. It's also listed today, your lordship, number 27.
So we may seek a week's accommodation, my lord, 27. Because that
For-
is the connected writ appeal, my lord.
May be tagged along with.
To be listed with readable number
Writ appeal number 1710 of 24, my lord.
171024 on
Any convenient date.
16th April.
My lord, may I request for shorter date because the issue is very simple, your lordship, whether.
First step.
Very well.
Grateful.
This number 5. To Lokesh KV.
Lord, this petition has been filed, wherein the single judge, my lord, has directed the respondent police to assist in implementation of the order passed by the honorable magistrate in taking possession. The order is passed under section 14 of the Securitization Act. Even after the direction was that within one implemented order of the magistrate. There was multiple visits to the police station. Lord, even the order was communicated along with a letter to the Annexure B on 13th of February itself, which was received by them on 14th. Even till yesterday, my lord, we are making multiple attempts, but the bank is unable to get the order implemented without the assistance of the police. Police is, for some reason, my lord, is not, they are not, in fact, they are only saying that we'll see tomorrow, next week. But rather than implementing the order, they're not taking any positive steps.
It is for you to file, no contempt.
Lord, it is a direction, my lord. In fact, they did not, that order is not been annexed. Annexure A may kindly be looked at.
To extend the police protection, number 1 is Home Department for taking possession. That is what is observed. Respondent shall implement this direction in a period of 1 week. Just find out.
I'll take instruction.
Notice returnable on 17th March to be listed at 2:30. Much.
For the complainant, my lord, because of the willful disobedience of the order passed by the learned single judge, my lord. Complainant served for 35 years for the aided institution, my lord.
8th April notice.
The PL matter, still number 7. Hence Pritesh.
Your lordships, the petitioners are before this honorable court aggrieved by the non-implementation of section fully the establishment of tree authority. The petitioner is in a
Section 3
registered
of?
trust. Non-establishment of tree authority, your lordships.
Tree authority.
Tree authority, section 3.
Under the act.
I will furnish the act itself, your lordships.
No, there is a tree authority.
Yes, your lordship, specifically
Officer rather.
for Mangalore, your lordships. Now,
This is for Mangalore.
for Mangalore. Now, I will take your lordships through the petition, your lordships. Just
No, which is the provision which contemplates the
section 3, your lordships.
status. Is quoted here anyway. Right.
Furnish the enactment itself. What has actually happened, your lordship, is that RTI are furnishing government notification, your lordships. Now, the act specifically states that the act at section 3 specifically states that every rural and every urban area is required to establish tree authorities by way of notification. The forest officer, the deputy commissioner, the superintendent engineer, and other members should be a part of the tree authority. Now, as far as Mangalore is concerned, your lordships, RTI applications were filed for furnishing of any such notification for establishment. After constant filing, your lordships, page number 77 of my petition, they furnish a notification at 2009, your lordships. Another information sought in the same RTI is, your lordships, that any meetings that have been conducted by the tree authority, where they furnish information stating that no meetings have been conducted 6 months, your lordships. Now, greatly aggrieved by this fact that even though a tree authority had been established in 2009 till 2024, and as on the date of the RTI application, no meeting had been conducted by the
the tree authority that had been established as per the notification. Now, the petitioner goes a little step further, Your Lordships. Now, concerned with the fact that this is the case of the whole of state of Karnataka, they filed a RTI for the whole of state of Karnataka for the establishment of tree authorities.
The petitioner which is a registered, madam. The petitioner which is a registered society under the provisions of the Karnataka Registered
Lord, may I
Society,
make
the
one submission?
notice.
My lord may see the prayer that is sought, my lord, and annexure A,
Represent.
addressed to His Excellency the Governor also is made a party.
Then you.
Page
deal very-
45.
Where is that?
Prayer is only a writ of mandamus, directing respondent one to take
Chief Secretary.
action pursuant to the representation made by the petitioner dated 18/6/2024, wide annexure A.
Hmm.
Annexure A, the first, my lord, is addressed to His Excellency the Governor.
We'll ignore. Ignore that. What did you take? Registration of Society Act 1960 and stated to have been engaged in undertaking the projects relating to preservation, upliftment and conservation of the environment to ensure the maintenance of biodiversity and environmental cleanliness, etc. Has filed this public interest petition raising a grievance that in respect of the Bangalore urban area, where Bangalore urban development of Bangalore city corporation is functional as local body of self-government, a tree authority which is required to be constituted under section 3 of the Karnataka Preservation of Trees Act 1976 has not been constituted. Section 3 of the Act speaks of establishment of tree authority to provide that the state government shall by notification constitute a tree authority for each urban area and for each rural area. Subsection 2, small a, lists the members by whom the tree authority shall be constituted. A representation, paragraph dated 18/6/24, figuring at annexure A, is made by the petitioner, which is not responded to by the authority. Learned additional comment of it, paragraph. Appearing upon service of copy of the petition in advance, points out that the representation is addressed to the Honorable Governor. The representations will be treated to the rest of the competent authorities only. From a stated learned advocate for the petition. Full stop. Notice written. Notice returnable on 20th of
Your
March.
Lordships, if I may add,
Because upon that day, just say that we'll do it or we'll not do it.
Your Lordships, if I may add, it's not only with regard to Bangalore, Your Lordships. After the petitioner files RTI for annexure M, Your Lordships, translated copies at page number 89. They give a list of appointments, Your Lordship, three authorities, Your Lordship. So most of the and almost most of the rural and urban areas.
Stated the petitioner, then further. So it is for entire
State of Karnataka.
At this stage, learned petitioner submitted that the prayer to appoint this tree authority is advanced in this petition for entire state wherever it is not appointed.
Grateful.
Can be disposed of today itself, but let us.
No,
what
my
is the-
lord, I'll get the instruction then. I'm obliged. my lord.
Grateful. Your Lordship.
Still number 8 to VR Balraj.
Lords, I appear for the petitioner, my lords.
To be listed at 2:30.
Lord,
Petition shall be listed at 2:30 on 26th of March in view of the compass of the
obliged.
additional government advocate shall taking the instructions.
Lords, I appear for petitioner in
Yes.
serial number 8.
Still number 8.
Yes, I appear for petitioner, my lords. The
Serial number 8.
yes, I appear for petitioner, my lords. My lords, am I audible, my lord? Am I audible, my lords? My lords?
Yes, please.
Yes, sorry, my lords, there was a small hitch. My lords, the petition is a public interest litigation, my lords, filed by the villagers, my lords, of Ramdev Kavalu village, my lords. There, my lords, the respondents number 3 to 7, my lords, have encroached upon government land, my lords, which also includes, my lords, Gomala land and some part of the graveyard, my lords, and tank, my lords. Hence, my lords, we have given a representation as per Annexure D, my lord. Yes, much.
Notice written about 8th of April. Yes.
Much.
Next.
Still number 9. Mr. Sharon Desai, party in person.
My lord, I'm the petitioner appearing in the party in person. My lord, this is a PIL filed at Gulbarga bench and the Gulbarga bench, and this has been transferred to the High Court in accordance with our notification last year, my lord. My lord, this matter is related to the illegal construction of apartment buildings in Gulbarga city, my lord. Nobody seems to follow any kind of approved plan from the corporation, my lord. They get the approved plan, but they build apartment in violation of setbacks. My lord, kindly see the Annexure B. Recently, I got an order from the Gulbarga bench. This is the next apartment building next to my house, which is in violation of complete building bylaws and everything. And order was to demolish this structure. Order to the commissioner to demolish this structure, my lord. But still no action has been taken by the authority, my lord.
So this order is passed by a single judge.
Yes, my lord. But I just
Okay.
I just made a reference to
Same
this
petition.
in PIL, my lord. But I'm seeking for the entire city, my lord, Gulbarga city. My prayer, my
839 is the final.
but just a reference order.
It was not a PI.
Not the PIL. No, the petition is PIL, my lord, but that order has nothing to do with the PIL. But I just
No.
got a reference order.
That petition was PIL, page 39.
Which one? No, that was not PIL. That is single judge, my lord. Which I just made a reference as a Annexure B. But my prayer and my lord, issue direction to the respondent number 1, 2, 3, and 4. Which is nothing but commissioner. This is a deputy commissioner, fire department, and the rear art department to inspect all the buildings which are under construction, and then submit the report for violation, my lord. In case of there is a violation, I also this honorable court can direct under section 331(3), my lord, to demolish the portion which has been excessively built, not in accordance with the bylaws, my lord.
The petitioner party in person. By filing this petition, or styling it as public interest petition. has advanced the following prayers. Has advanced the twofold prayers. Firstly, to direct the respondent 1, 2, 4, and 5 authorities to inspect the apartment buildings within limits of Kalaburgi Mahanagara Palike for an illegal construction by the builders and owners for building violations of the approved plan bylaws, as well as in respect of violations related to building height, setbacks, fire safety measures, and RERA registration certificate. Full stop. It is next prayed to direct the responder 1 and 2 to issue notice under section 321 of the Karnataka Municipal Corporation Act, and to take action to remove the portions of the buildings that exceed the approved construction height and setbacks. It is the case of the petitioner that it is stated by the petitioner that the petitioner has made a representation dated 1/10/24. However, the same is not attended to. It is the allegation that portions of several buildings are illegally built and are violative of the approved building plans. Full stop. The pleadings paragraph.
My lord, at every stage of apartment construction, the authority should go and examine the construction site, my lord, to see whether they're following the bylaws and constructing in the
Stand in
plan, my
the
lord.
background to stand in the background to seek to support the prayer. Is found is raised under comma extracting from paragraph 4. So paragraph 4. Full stop. Reading of the aforesaid reading, which are the facts constituting the case of the petition, invariably go to show that the petitioner has made too general and too vague allegations about the illegal construction of the buildings and alleged non-compliance of the building plans, etc. Full stop. On the basis of such vague, general, and omnibus averments, it is not possible to take cognizance of the grievance of the petitioner in the public interest jurisdiction. Full stop. The petition is not entertainable on the aforesaid ground alone, since it is based on two general premise of facts. As a matter of fact, no particular facts are pleaded at all in respect of the alleged violations of any building or construction. Full stop. Leaving the petitioner open to approach the competent authorities in individual cases if the specific facts are available regarding the alleged violation of the building plan. This petition is not entertained and stand dismissed
Much of it.
on the aforesaid ground.
This is seal number 10, Mr. P. Mahesh.
Petitioner. I'm seeking for a writ of mandamus, my lordship, directing the respondent authority, third respondent authority to issue NOC, my lordship, as well as consider my application for granting the quarrying lease, my lordship, which is pending still, which is not earlier, my lordship, this honorable court has pleased to direct the respondent authority to consider my application, my lordship, by receiving the NOCs from the authorities. But still today, my lordship, though the second respondent written a letter to the third respondent, my lordship, they have not at all submitted the required NOC from the revenue department. Forest department has clearly issued NOC stating that there is a mineral is existing, and technical report is also submitted before the authorities. But the only revenue authorities have not submitted their NOC, my lordship. Therefore, my application is not yet considered. I'm seeking for writ of
My lord,
mandamus.
yesterday, my lord could recollect. My lord, one writ petition, my lord was pleased to dispose of WP 5612 of 2025. Where the representation, my lord, had provided it is pending and not, my lord, disposed of.
Same line.
My lordship, my lordship, it is pending or not disposed of. My lordship, I have produced a document to show that the very authority has written a letter to the revenue authority to issue the NOC in
No,
the year
I'm just-
2023.
I'm just being,
Might not be pending by deciding in your favor also.
Yes, my lordship.
it's just a precautionary,
Yes,
precautionary
precautionary.
measure.
We're only saying that if pending, then. We'll be-
Yes, my lord, yes.
If you're granted or rejected, then different.
Yes, my lord, precautionary measure.
Because the law mandates, my lordship, within 90 days, they have to submit the
In this
NOC.
petition, filed under Article 226 of the Constitution, as highlighted by learned advocate Mr. So-and-so, the petitioner. The prayer is to direct the Deputy Commissioner, as respondent 3 hearing, to submit no objection certificate for pouring lease, pouring purpose, as paid for, as sought for by respondent 1 in letter dated 28/12/23. Full stop. Letter dated, it is further prayed to direct respondent 1 authority to grant, 1 to 3 authorities to grant pouring lease in favor of the petitioner by considering the applications of the petitioner which are stated to have been filed on 30th/9/14 and 29/9/14. The petitioner claims pouring lease rights in respect of the land bearing survey number 80, Tagarupura village, Kollegal Taluka, Chamarajnagar district, which had measures 6 acres and 4 acres respectively. Full stop. The aforementioned letter dated 28/12/23, from a copy of which figures at page 115 into annexure N, is addressed by the Director of Department of Mines and Geology to the Deputy Commissioner Chamarajnagar, which is regarding issue of opinion of the Revenue Department about the application submitted by the petitioner for grant of pouring lease, full stop. The averments in the petition paragraph and the aforesaid aspect of addressing of the communication by the director requiring the revenue authority to give opinion, goes to show that the application of the petition is in process of consideration by the authorities in accordance with law. Also, in the circumstances, without going into the merits of the petitioner's case, since the petitioner, since the applications are claimed to be pending, the present petition is disposed of by directing, who will decide?
My lordship,
Respondent.
third respondent has to
Directed
issue
respondent
the
to-
NOC and
to
second
to their competent authority to consider and decide the application of the petitioner aforementioned for grant of pouring lease in the said, in respect to the said land, provided the same is not so far decided. Petition is disposed of
within some period.
within period of 8 weeks from the date of service of the copy of this,
Obliged.
provided it is not decided.
Sir, writ appeal matters, seal number 11, Mr. Gaurav.
Appealing, my lord, there is a delay of 160 days in filing of this appeal, my lord.
Notice,
Please, my lord,
notice returnable on 7th April.
grateful.
12 is urgent, seal number 13, Mr. Satish V.
Appearing
Number
for-
13.
I'm appearing for the appellant, my lord. The appellant is a banking company, my lord. We have advanced a housing loan to the respondent number 3.
Since the respondent number 3 defaulted in repayment of the loan, my lord, we were constrained to initiate proceedings under the SURFACE Act. And by following all the due procedures under the SURFACE Act, my lord, we have taken possession of the secured asset. And the secured asset was also leased to various tenants, my lord. We have evicted the tenants by following the due procedure of law, and we have taken possession of the secured asset. At this point, my lord, the respondents number 1 and 2 approached this honorable court and they filed a writ petition. They challenged the section 14 order, my lord, and they claim that they are the owners of the property and that I have played a fraud. And they say there's a difference in the khata number. I have played a fraud and I have mortgaged this property and obtained a loan from the appellant. The learned single judge, my lord, initially had granted a stay. If I may take the court through the order passed by the learned single judge, my lord, it's on ink page 16, my lord. Ink page 16, the order dated 30th August at the bottom, my lord. Learned counsel for the petitioners submitted the petitioners had mortgaged separate property with LIC housing for offering loan, and subject property was mortgaged by respondent number 2 to respondent number 1 with different khata numbers. Issue emergent notice to respondents. Interim order as prayed for till next date of hearing. My lord, initially a stay is granted, and when I get notice, I enter appearance and I file an application for vacating the stay, my lord. On the date my IA for vacating the stay is put up before the court, the learned single judge has directed me to hand over possession of the property itself, my lord. That is the order under challenge at 611, my lord. The respondent number 1 is hereby directed to redeliver the physical possession of the property bearing house number 30, khata number 144, situated at so and so. Hand delivery ordered, my lord. In exercise of an extraordinary jurisdiction, my lord.
This order was passed on 6/11/20.
24, my lord.
6/11.
6/11/24, my lord.
Today, 4 months have passed.
My lord, we have filed this at the earliest only, my lord.
Still, the possession is not ready.
Not yet, my lord. We have not yet granted possession.
Contempt is also not filed.
They have not made an attempt, my lord. After that, the matter has not been put up before the court.
So what was the prayer in the main petition?
In the main petition, my lord. The main petition, I have produced it, my lord. They were seeking for, they had challenged the section 14 order, my lord.
14.
The section 14 order.
And you have taken possession.
I have already taken possession, my lord. So it is the case of the respondent number 1 that they are owners of the property. So the property number is the same, but the khata is a different number is what they allege, my lord.
So order under challenge in the writ petition by the respondent herein was under section 14 of the Act,
Please, my lord, please,
whereby the possession was directed to be delivered
please, my lord.
to you.
Yes.
Then you took possession pursuant to that order.
Please, my lord, I have taken possession. Throughout the SURFACE proceedings, my lord. Throughout
Borrower is different and the petitioner is different.
Petitioner is a bank.
petitioner, I'm the secured creditor, my lord. I'm the bank.
No, appellant is the bank, sir. The
No, no,
original
appellant
peti-
is the bank, yes.
My-
Original petitioner
The original petitioner is
was not the borrower.
He was not the borrower, my
He's
lord.
not the
Who was he? Third party.
He's a third party, my lord. He's a complete stranger. I don't know him. My borrower is respondent number 3. It is his property that I have taken mortgage of. And
What prompted the third party petitioner to file a petition?
my lord, he claims that he is the owner of the property, my lord. And throughout from 2021,
Set up.
throughout the period during which
Who is the borrower? Is part
the borrower is respondent number 3, my lord. The respondent number 3 is my borrower.
in this
In this petition, my lord. In the present petition, I have granted a loan to the respondent number 3. He is my borrower. 3, 4, 5, they are all co-borrowers. They are my borrowers, my lord. And I don't know who respondents number 1 and 2 are. They are strangers. They claim that they are the owners of the secured asset.
Mr. Raghu.
Huh.
Is
Mr.
it-
Raghu is my borrower. my lord.
Borrower. And the original petitioner is Govindaraju.
Please, my lord. The petitioner before the lower court, before this learned
Or
tribunal,
learned, what is the good name?
Rupa Ron.
Rupa Ron
Yes.
for the appellant company. Respond number 1 herein. Filed a writ petition in which it was prayed to set aside order dated 28/11/23 passed by 9th Additional Chief Metropolitan Magistrate, Bengaluru, in criminal miscellaneous number 6838 of 2023, which was the order in the proceedings of section 14 of the SARFACI, full name Act. The appellant company had taken measures under the said Act for the purpose of recovery of dues from the borrower, who is respondent 3 herein. Full stop. Noticeably, the original petitioner, respondent 1, was not a borrower, but who claimed interest in the property and filed the petition. Full stop. In the said writ petition, learn a single judge. The said petition was entertained by learn a single judge and passed following order initially on 30th/8/2024. So page 16, this Roman 1. The petition was next posted on 27/9/24. The interim order was ordered to be continued. Full stop. The petition was next taken up on 6/11/24. Paragraph, in which on which date the following order was passed. And quote the order, Roman 2. Paragraph. It is the aforesaid order, which is brought under challenge by filing this writ appeal by the appellant company. Order of learned single judge, though interim in nature, though apparently interim, directs respondent number 1 to redeliver the physical possession of the property in question, which is house list number 30, Khata number 144, situated at Parapana, P-A-R-A-P-P-A-N-A, Agrahara village, Begur Hobli, Bangalore South Taluka, to the petitioners on or before 8/11/24. In view of the paragraph, learned advocate for the appellant would submit that not only the order passed by learned single judge is a mandatory order requiring the appellant to hand over back the possession to the petitioner. It was stated that the bank was already in possession. Bank had already taken in possession the company was already in possession and had taken the possession pursuant to its exercise of powers under section 13(4)
Please.
of the Surface Act. Full stop. Full stop. Prima facie from the facts of the case, 3 material aspects emerge. Firstly, the very petition of the very petition filed by the petitioner was not maintainable, as the remedy of the petitioner was under section 17 of the Surface Act. It is a well settled principle by cadena of judgments by the Supreme Court that when the section 17, that in wake of the provision of section 17 of the Act, the writ jurisdiction cannot be exercised by the High Court. Full stop. No extraordinary circumstances could be noticed in the facts of the case, which would have permitted a single judge to entertain the petition. Full stop. Secondly, as stated above, the order is of redelivery of physical possession, which possession the appellant company was already having in accordance with law, taken in accordance with law. Full stop. The interim order is of mandatory nature and has definite trappings of finality. A strong prima facie case is made out. Paragraph. Appeal is admitted. Impugned order of law on a single judge is hereby stayed. It is observed that pendency of this appeal shall not preclude law on a single judge from proceeding with the petition and decide the same in accordance with law.
Great.
Seal number 14, Mr. Nayak NR. 14.
Nobody is there. Pass over.
My lord. The serial number 82, my lord, today, main matter is posted, my lord. Kindly maybe connect along with 1492/2024, my lord.
All connect.
Serial number 82.
230, my lord.
15 notice returnable on.
Seal number 15.
14 is to be kept back, to be connected with. So 15 notice returnable on
Please.
17th April. It is not your matter, Mr. Commented.
Serial number 15.
Then 16 also, same order. One. Notice returnable. 17.
Syllabus 17. Amrit Chaudhary.
Either by intentionally or otherwise, my lord, proceedings of this court are abused. The respondents herein file a writ petition seeking voting rights. They were ineligible voters. They file a writ petition seeking voting rights. And an interim order was passed on 13/8/24, permitting them to vote and to keep the ballot papers in sealed cover. Election takes place, they vote. Thereafter, they file a memo to withdraw the writ petition. By order at page 79, 30th September, petition is dismissed as withdrawn without there being any specific order either to count those votes or not to count those votes. No such order is passed. Then it appears the returning officer did not take up the matter for counting even the other votes.
So all the petitions wanted to cast vote.
Cast vote.
So they casted vote.
They casted vote. They withdrew the writ petition without there being any order for counting their votes.
So election to which? Election to
Election to
Cooperative Bank.
Yes, my lord, it's a cooperative society that sets respondent number 4.
All right.
Then very same person, 23 persons, along with a contesting candidate, they file a fresh petition. Of course, they say that we had earlier filed the petition, we have casted vote. And they have withdrawn is also mentioned. Now the learned single judge passes an order. Kindly see the operative portion without noticing the fact that page 33.
Disposed of without notice?
None of us were parties, only the state and the election authority returning officer were parties.
So you are society.
Page 33, probably learned single judge did not mean to allow those votes to be counted, but the word used there is, page 33, the returning officer shall count the votes cast in the election. A general sentence is used, therefore now the returning officer counts the other votes also, announces the result, but records a finding, a note that these ballots are being kept separate, counting and declaring the result.
But that was upon your objection.
That was, they were.
Neither in the earlier proceedings nor in the instant order. The issue of invalidity of votes is not addressed.
Did not addressed at all.
So how do the returning officer or counting officer will say that?
Because the direction is.
No. Why set apart? He will count all the votes.
He did count all the votes, but these ballot papers are kept separate because earlier there was a direction to keep it separate.
Earlier in which?
In the matter which is withdrawn.
Earlier.
Earlier there is a direction.
Interim
Direction.
So then that interim direction will not survive after withdrawal.
Actually, it will not survive, and there could not have been a direction to count those votes.
What do you want now? What do you want now?
Now I have said, now that these ballot papers, fortunately those ballot papers are this thing, this order may have to, I would respectfully submit those votes. They cannot have the benefit of that interim order which they had withdrawn.
Appearing for the respondent.
Who will decide about the validity of votes? Whether
it's been decided, they are declared as ineligible. They, in spite of it, they had an interim order.
Which is the order?
Please, my lord. No, not by the High Court.
Wherever.
Yes, my lord. It is their case itself that they have been declared as ineligible voters. That should not have been done. Therefore, permit us to vote. That was their case itself. In fact, in such cases, the courts have taken this view, my lord, that in case the society has not at all followed issuing of notice, then only voting will be permitted. If they have issued notice, question of delay or number of days, etc., will not be gone into. They will not be permitted to vote or count those votes, is the view taken by, of course, both by learned single judge in 3 cases, all of them. Probably here the learned single judge did not mean to count all the votes, but the word used is count the votes cast in the election. That has made all the difference.
For invalidity stance.
Lordship, kindly turn to page number 76, my lord. Wherein the writ petition is withdrawn, the petitioner in the top noted petition, page number 76, my lord. Petition may kindly be permitted to withdraw the top noted petition, and the respondent may be permitted to declare the results of the election. By recording this memo, my lord, writ petition is dismissed. After recording this, my lord, they have directed to declare the results, my lord. Thereafter, since they have not declared the results, my lord, petitioners and other other members of the society, my lord, who have participated in the election, filed writ petition and sought for direction to declare the results, including the petitioners, my lord. Now the results have been declared and managing committee is also elected, my lord.
Council, listen, come to page number 83.
Right. Learned Council petition has filed memo seeking leave of the withdraw the petition.
Mr.
Aforesaid memo is taken on your lordship. Therefore, my lord, your lordship can return to the memo.
Accordingly, the writ petition is dismissed as withdrawn. Now, this order does not confer any right on you.
In terms of the memo.
That is
memo
not said
taken
so.
on record.
That is not said so.
Right, memo
You
is
will
taken on
write
record.
100 things on the memo. Unless it is recorded in the order, that you won't get any right. The writ petition is simply withdrawn. That means to say it is dismissed as withdrawn.
And my memo is taken
You
on-
have not been conferred any right whatsoever by the decision of this court in this judgment. So that means to say the invalidity stands.
Right.
Thereafter, the votes polled by other persons have to be counted and the result has to be announced. That's all. That's the only thing remaining.
Memo is filed, my lord. The wording used is, my lord, memo is taken on record, my lord. Therefore, there must be some, so usual orders will be.
So everybody is representing? You are for all original petitions,
Yes.
6
Yes,
to,
ma'am.
6 to 29.
Yes, my lord. My
Ma'am,
lord,
for respondent number 1, 3 and 5, my lord.
123, my lord.
1, 3 and 5.
5, please.
6 to, why number 2 is left out?
2 is represented by an counsel, my lord.
Kiran
public
Kumar,
counsel.
panel advocate.
Yes, sir.
And now the
Kiran Kumar.
managing committee is also elected along with the elected members, my lord. Elected members who are petitioners before the appellants before this, including them, and the persons who have casted their vote, all of them joined together and body has been elected, man. Managing committee is selected, man. Unless they can learn, they have only cause to challenge the election petition. Now order is implemented
Part
and
2 and
committee.
Cooperative Election Commission.
The one Miss Kiran Kumar,
There is a Cooperative Election Commission.
Pardon me?
There is a Cooperative Election Commission.
Please, my lord.
it's actually called as election authority.
So 2 and 4 not represented.
No, my lord. They have to be served.
So you give copy to
Please.
2 and
But now the committee is elected, including the appellants and the other members, my lord. Therefore, my lord, when they have already matters, they have implemented the order and the election commission results has been implemented and committee, managing committee is already taken place and working. My lord, therefore, my lord, at the most, my lord, they can challenge by filing the election petition. My lord. But in fact, my learned single.
Third learned senior advocate, Mr. Professor Ravi Verma Kumar.
Jai Kumar.
Sorry, Jai Kumar. Assisted by, sorry, learned advocate, Mr.
Jai Kumar is.
Jai Kumar. What is your?
Chaudhary, Mr.
So and so for the appellant. From a learned additional government advocate, Mr. Harish for this one more 1, 2, 4.
1, 3 and 5, my lord.
1, 3 and 5. And learned advocate, Mr.
RP Somashekare. RP Somashekare.
RP Somsek.
Somashekare.
For this one 6 to 20. Full stop. Learned advocates X. Notice returnable. Notice for final disposal.
Please, ma'am.
Returnable on 14th of March.
Please, your lordship may kindly permit me to serve the panel advocate for respondent number 2
And 4.
and hand summons to respondent number 4. In addition,
So on that day will dispose of
Well,
once you.
One
no,
more
respondent
submission.
number 2, I will,
Today any order you want? Any interim order is necessary?
My lord, now one more question.
No, no, no,
Now
my lord,
all
not,
the
not,
persons
not
who
on
have-
interim. Of course, I have prayed for an interim order, but your lordships have given 14th as the date. Therefore, I will, your lordship may kindly permit me to serve on Kiran Kumar for respondent number 2.
Learned advocate, the service to respond to may be effected in addition to normal mode of service by serving copy of the appeal to learned advocate Mr. Kiran Kumar,
Kiran Kumar.
who appeared before learned single judge. Full stop. Service by hand delivery
For respondent number 4,
is
hand delivery.
permitted to respond number 4.
Please,
So the appeal shall be listed at 2:30.
One
Please.
more submission, my lord. Since all the members will be affected, by in view of if any orders are passed, let them make all the members as participants.
we have made whoever is necessary, we have made them participate.
You are going to affect it or?
But it is, since all the members will be affected, my lord, therefore they are necessary participants. Since they have already participated, some of the members have been elected. If any orders passed, my lord.
Result is not
committee-
declared.
Results are declared,
Result-
managing committee is, elected body is there, my lord. Already body is constituted, my lord. Elected body is constituted, my lord. They have to make the elected members as, members, my lord. Managing committee members, they have to make.
The votes of respondent number 6 and onwards.
Please, separately,
Kept separately and counted separately.
Counted
Maintained
separately.
separately.
yes, yes.
Not part of the result.
No, no, part of the result,
of
but
the result.
kept separately, counted separately, kept separately.
Will
My lord, now the managing committee is elected, my lord. Managing committee members, president, vice president, they will be the necessary parties to this petition. If they have not implemented, my lord, the committee will be affected.
I will take the steps if necessary.
Committee is a necessary party, my lord.
would like to join?
Please, my lord, I will take necessary steps even for that. Your lordship may call it on 14th. By that time, I will take necessary steps if necessary.
Because quorum, everything gets disrupted and
I will get, the-
constitution itself gets disrupted.
I will
That's
get those persons implemented.
That's the reason.
So
Your lord-
before leave to implement the elected persons
Please,
as party respondents. And lastly, notice by hand delivery
please,
to the elected persons also,
Please.
newly added party also.
please.
The cost title shall be, is permitted to be amended as prayed for by learned advocate for the petition. But this will put an end.
Please,
Seal number 18, commercial appeal.
Was appearing for the appellant. My lord, this is a defendant's appeal challenging the order dated 16/12/2024 passed by the trial court. My lords. Lordship, we are challenging the order dated 16/12/2024 passed by the trial court. This is a defendant's appeal. The suit was partly decreed in favor of the plaintiff, stating that certain alleged waterproofing works have been completed by the plaintiff and that the dues to that effect has not been paid by the defendant. My lords, one of the main grounds raised by the defendant in the suit was that the suit itself is not maintainable for the fact that
Notice
there is,
returnable.
my lords, I'm praying for stay, my lord.
What stay?
Stay of the operation of judgment and decree. My lords, if I may, please peruse page number 43 of the appeal, my lords. At para 27, there's a specific finding given by the trial court that if I may be permitted to read, my lords. Therefore, as a result of all these facts, I accept the defense of the defendant that the defendant had entrusted the work of waterproofing of TJS and apartment complex not to the plaintiff's proprietorship concern by name Court and Seal, but to PW2 Dharani Gowda and PW3 Michael Pinto as pleaded in paragraph 5 of the written statement. Despite giving a specific finding that there is no privity of contract between the plaintiff and defendant, he has gone to decree the suit.
Can we stage at this stage?
My lords, we are willing to even deposit about 50% of the decretal amount as on date before the trial court, my lords.
In fact, in the order portion, they're not even parties to the suit, my lord. There are certain third parties. There are certain third parties, my lords. They're not even parties to the suit. And at order portion,
Will be granting stay, but on condition as usual, money decree, you deposit the entire amount, entire decreed amount.
it's about 50% entire. Please, my lords, entire amount. Please.
Notice returnable on 17th April. In the facts of the case, there shall be stay of judgment and decree passed by learned 83rd Additional City Civil and Session Judge, Commercial Court, Bengaluru, in Commercial OS number 329, 2023. On condition, however, that the appellant shall deposit before the next date, the decreed amount along with interest. Decreed amount, entire decreed amount.
Please, my lords. Before the trial court, my lords.
So this will be order common in appeal and IA. IA shall also be listed along with that. So this will be an order in IA. In both notice returnable and then order in IA. Yes. Deposited before, where you will deposit?
Before the trial court.
Before the trial court. On that, they will pass if necessary the order regarding deposit, investment rather.
My lords.
On before 17th, you deposit.
Before 17th of
Returnable date.
please, sir.
Seal number 19, state appeals.
State appeal, my lord.
Appeal for the respondent number 1, your lordship. In the first matter, we have take out notice and have entered our appearance and filed objection for the years. And I filed objection for the continuation of delay, your lordship. In the second matter, notice, we have no, I'll undertake the notice, your lordship. There is also a delay of 1082 days. I request your lordship to grant time to file my objection.
15th April.
Great.
What is the delay? 1082?
My lord, in the first matter, my lord, it is about 228 days, my lord.
And this 108.
My lord, that is the reason being, my lord, in the order impugned in the first matter, my lord, there is reference to certain findings of the learned single judge in the previous matter, my lord, where there was a remand order, my lord. Because that finding has come in the way, my lord, we have filed appeal in that matter also as a caution, my lord.
And then they want to file reply.
Very well.
So file it before next date. Otherwise, right? Delay should not go on.
Let them serve a copy.
Yes.
So,
Seal number 20, Mr. Raghavendra G. Gayatri.
In connected matter, there is a delay of 123.
123 days, yes.
My lords, if my lords may remember, I had raised my lord's preliminary objection and I sought for time to file my preliminary objection with respect to my lord's maintainability of their appeal. Lords, what is under challenge is, my lords, the entrustment or what learned single judge holds that entrustment order is without application of mine and directs the respondent state government to, my lords, reconsider the entrustment order on the ground of the same being non-application of mine.
What's your name?
My lords,
You are?
lords, I am for the appellant in main matter and respondent number 1 in connected matter.
That is 604 of 20.
Indeed.
So Raghavendra Gayatri.
Indeed.
You are Raghavendra Gayatri.
My senior is Raghavendra. Lords, Lords, I filed my preliminary objection on 18th of Feb 2025. Lords, I have relied upon my lord's decision of coordinate benches, wherein they have interpreted my lord's 12.3, 12.4 and
So 14 validity is under question.
The identical matters lordship has heard and reserved, my lord.
with
The
respect
same
to
issue
bias
is
is
involved, my
concerned,
lord.
my lords, writ appeal 19 and 15.
my lords, have heard and reserved. But my lords, insofar as my lords, non-application of mind with the entrustment order is concerned, they will not be a interested party. For the reason matter is sent back to the government. 12-3 report is not found fault with. Matter is sent back to the government for reconsideration. So it is yet to be reconsidered by the government. In that circumstances, they will not have a locus is what is held by the coordinate benches of this honorable court, my lords, which I have annexed in my preliminary statement.
Here,
of
what is the
objection.
operative force? Operative. order.
Page 101, paragraph 72, my lord, is the issue involved, my lord.
73, 72 also.
72 is the question, my lord, which lordship has considered in the connected matter also, where KEB regulations
my
were
lords, my lords have
considered. On the
reserved the
question of bias, KEB regulations were challenged, 14A, my lord.
How come the learned single judges sent it to the government to decide?
Lords, that I have filed the writ appeal because Pollution Control Board has already given a report on 16/11/2021 after conducting one more
Government
inquiry.
comes into picture for deciding whether inquiry is to be
True, my
made
lord,
or
it does come into picture.
My lords,
The government also comes into picture, taking into consideration, my lord, that it was the government, my lord, who entrusted the inquiry as regarding the government official and the loci.
I
So
am
that
not
is
a
why, my
government
lord,
official, is my ground. I am not a government official, I am a board employee. That is my appeal, my
You are a
lords.
pollution control board chairman.
No, my lords, I am an employee,
An
I'm an
employee of the
environmental
board.
officer of a board.
which is being constituted by the state government,
Independent board
independent body constituted by the state government as far as the central act is
under
concerned.
separate law.
Yes,
There is
Where
some
am I-
prima facie substance in what he says. So who will conduct the inquiry?
My lords, as per 2(3) of the cadre and recruitment rules of 1992, my lords, it is the board who is the competent authority along with regulation 13. Board after receipt of 12(3) report.
Do you think that we will not feel?
If my lords permit, my lords, I'll briefly state the facts.
What is your name, Mr.?
My lords,
You
lords, if I can say the facts briefly.
What is your name?
My client, senior medical officer. My name, Sridhar, my lords.
Sridhar. So Mr. Sridhar, we issue notice. Simple.
Notice is already issued, my lords.
Notice already.
Both matters notice is already issued.
both are connected matters.
Wait, because that main matter we are only,
Bias, my lords, have opined already and have.
might not cut, but if some reasoning may interact. So wait.
But my lords, my challenge was on the ground that on 16/11/2021, after receipt of 12(3) report, board has appointed another chief medical officers to conduct a detailed inquiry and he submits a report. On that, already board takes a decision on 16/11/2021 that there is no dereliction of duty
In this,
that- in this factual matrix. And my lords, on that, the 12(5) remedy is not been invoked by the Lokayukta also. In that wake of the matter, after 2 years, government, who is not an authority to entrust the matter, on 7/11/2023, on 7/9/2023, beg your pardon, my lords, entrust the matter without referring to the report of the pollution control.
My lord,
without what, where it is exonerate.
Exonerate.
my lord, as
And my lords, learned single judge says because KCSR is adopted,
So the decision of the government may go in your favor.
my lords, no,
Government may not go in-
government has entrusted to. Lords, if decision of the, my lord, that is what is held in my lord's coordinate bench.
See, according to you, a departmental inquiry was conducted and you were exonerated.
No. 12-3 report was forwarded by Lokayukta. On that preliminary inquiry by a chief medical officer was conducted with respect, what was the complaint is that, my lords, one company named Jubilant Limited is
Whatever it
releasing
is.
effluents to the,
Whatever it is.
then on that report is filed before the board and board sees that what is the allegation told in 12-3 is not at all the allegation and there is no dereliction on the part of the employee. Board, after inquiry of preliminary report, comes to the conclusion.
Thereafter, after a lapse of 2 years, the matter is referred back to Lokayukta.
By government, not by the board.
By
Board releases it. Board, I am being exonerated. Only one term is that, my lords. May I just. My lords just asked if government favors me in 14A while reconsidering the 14A entrustment. Lords, they have remedy under 12.5. One thing. Second thing, when board has taken a decision to withdraw, for 2 years they have not taken the remedy of 12.5.
So you are right now against the very direction whereby the government is given liberty to apply mine.
Yes, I am against that. And in their writ appeal, I am against their maintainability also in view of the coordinate bench's decision also.
What is the decision?
My lords, where coordinate bench, my lords, I have annexed to my preliminary statement of objection. They have clearly held when entrustment order is set aside and government is directed to reconsider it. When 12.3 order is not, righteousness of 12.3 order is not touched upon, then it is at the stage of government. So unless government takes a decision on it, Lokayukta will not get the locus to challenge the same. And if the government takes a decision against the Lokayukta,
There he appears to be entirely right. In respect of
their appeal.
preliminary objection in respect of your appeal. Please, my lord. He appears to be entirely right. Prime office. How can you challenge when this decision is not come?
It is not yet come, my lords. 14A entrustment has not yet come.
My lord, as far as 14A entrustment is
just,
concerned, my lord,
we
it
put
is
off
subject to their.
I'll leave it to my lords, until that decision altogether can be taken to.
altogether, so
Yes,
that our reasoning may not
my lords. Yes.
go in conflict.
With respect to para 71 and 70, by the learned single judge has reasoned it on bias that, my
No,
lords,
but there
have
are
to
other aspects also involved over here, which is not the subject matter there.
Please, my lord, I do understand. That
Yes,
being
my
the
lords.
situation, my lord,
My lords,
we
this-
may wait for the outcome of that.
This is the
particular-
judge. May I make one submission? Writ appeal 15 and 19 of 2024. Of 2025 and 19 of 2025.
Pursuant to 12.5 report to the governor and the competent authority.
After 12.4, 12.5 is there.
12.5. Again, the matter is referred to Lokayukta now.
No. my
12.4
lord,
interest.
may I just clarify?
So 12.5 is
Now, based on a
12.5 is not,
complaint,
12.4 is not come to picture.
not
on.
exhaust. Part of 12.5 will operate in your favor.
My lords,
The first part of 12.5
will operate in my favor.
in your favor.
12.4 has not come to picture yet. So
12.5.
12.4, after 12.4, 12.5 will come. So government has not taken a decision yet. 14 is sent back. 14A is sent back. 12.4 government has to take a decision. So government has not taken a decision yet. If government takes against my favor, I will challenge.
if
Competent authority, subsection 4, shall examine the report forwarded to it under subsection 3 and within 3 months of the date of the receipt of the report,
yes,
made the cause and intimate to Lokayukta. This has done.
board has taken, government has not taken.
My lord,
They-
may I just?
What is under challenge before learned?
For the things have progressed, up to subsection 4.
Please, yes.
The
As
things
far
have
as board is
progressed.
concerned,
Please, my
yes,
lord.
12-4.
12
12-5 is not exhausted.
That is what it is.
Without exhausting, they have filed.
12-3, my lord, is my recommendation. Based on my recommendation, my lord, it is the government who's entrusted inquiry onto this under the CCA rules, my lord.
But irrespective of operation of 4 and 5.
Please,
and
my
the scope thereof, looking to the nature of the direction governed by law on a single judge, your petition is premature. Irrespective of whatever you say about 4, 5 effect, operation.
My lord,
But looking to the nature of the direction given by law on a single judge, your appeal can be said to be premature.
my lord, for the reason, my lord, it only says what the learned single judge says, that the recommendation, my lord, to the government, stating that the entrustment has to be, that the inquiry has to be entrusted to the Lokayukta. My lord, the tenor, my lord, has probably been misread, stating that it appears, my lord, that the recommendation by the Lokayukta to the government says that the entrustment has to be done only to the Lokayukta, but that is not the case. It is only a request. See, prima facie, it appears that there is misconduct. Prima facie, it appears to be misconduct. Therefore, it is requested for the government to entrust inquiry unto the Lokayukta. I pause here. The tenor, my lord, it says that it does not state with any preceding words or subsequent words stating that it has to be entrusted only to the Lokayukta. This is the reasoning, my lord, which has been faltered with in this writ appeal, which is the subject matter of this appeal. I only make a request. Yes, prima facie, there appears to be some misconduct. The government, my lord, it applies its mind and it takes into consideration not only the submissions given by them, not only the submissions given by the board, not only the submissions given by an inquiry officer as appointed by the board, who it appears to protect the government official, but it adds additional grounds stating that prima facie there are certain reasonings wherein certain rules have not been complied with. Therefore, we deem it appropriate in our wisdom to entrust inquiry under the Lokayukta. Now, this appeal which I have filed, my lord, is only on the ground wherein the learned single judge says that it appears that there is a direction by the Lokayukta to the government that the entrustment should be given to the Lokayukta and the Lokayukta alone. But that is not the tenor. It's only a request.
But ultimately, the discretion is vested with the authority
Yes,
concerned.
the discretion is with the
And
government.
that is the observation also, operative portion,
Yes,
the last two
I'm
paragraphs.
not about this, but my recommendation is quashed only on the ground of tenor wherein it appears. Yes.
That, my lords, they are
To
part
that
to my
extent
writ
it is
appeal.
quashed, but
Lords
there is
may
no
say
fault
it
as
in that
regarding the
writ appeal.
12-3 recommendation wherein the learned single judge says, yes, the government, that is the Lokayukta has the power to make a recommendation. That has not been found fault with. Then the power of the government to entrust inquiry either to the Lokayukta or to an independent body, that is also not founded fault with. But what is found fault with is only the tenor, wherein it appears to the learned single judge that a direction has been issued by the Lokayukta that the entrustment has to be given only to the Lokayukta. I am only on this aspect.
Lords, with the deepest respect,
Both of, yes.
all his arguments which fall into non-significance for the reason that board had taken a decision on 16/11/2020 which remains unchallenged and never 12-5 is exercised on it. So entire argument which he is now contending, which fall on insignificance on that ground itself.
But for operation of 12-5,
My lords,
there is no need to challenge that.
Yes.
for operation of 12-5, my lords, on operation of 12-4 is the competent authority which has to take a decision. Board is the competent authority under 12-4 which has taken
My lord,
decision.
may I just
Examine.
Indeed.
We'll put off this for some time. In the meantime, both of you give your synopsis.
Obliged. I will.
Writ appeal number 604 of 24 with writ appeal number 1346 of 24. To be listed for further consideration on. To be listed next on. We'll say 21st April. In the meantime, as early as possible, learned counsels for both the sides shall file their written synopsis and submissions. Written submissions and synopsis. Synopsis come written submission.
Lords,
My
in the
lord,
meantime, may I seek one indulgence that, my lords, with respect to 14A entrustment, let government not precipitate the matter. Because I'm a board employee. After, no, if entrustment is given, then inquiry will
That's
start.
the outcome of this matter, my lord, anyhow. Not aware about this.
Again, inquiry is entrusted, my lords, I'm asking government don't have the power to entrust itself.
Which is your appeal?
604, my lords, writ appeal.
The appellant of writ appeal number 604 is at liberty to move the court by filing interim application if any adverse development occurs in the inter-alia.
Grateful.
For my application for
It is as
delay-
good as what you are asking.
condonation of delay, my lord, my application, my lord. 123 days delay in filing my appeal.
Delay will condone.
Will
Delay
Oh,
in your appeal,
Yes, in my appeal.
So be separate order, having heard learned respective parties, and having perused the government's explaining the passage of time leading to delay, in the accompanying affidavit, the present interim application is allowed by condoning delay of 123 days.
123 days.
Deeply obliged.
Obliged. It's number 21, state appeal.
My lord, please, my lord, in respect of respondent number 2, my lord, Shivarudrappa Shetkar will appear, my lord, undertake to file the wakalat, my lord, on behalf of KSDL. Serial number 21, my lord, please.
I appear for 3.
Respondent number 1.
What do you want? Time?
Lord, the state appeal, my lord, there's a delay of about 217 days in filing the appeal. State appeal, my lord. There's a connected contempt petition also. Last occasion, my lord, notice to Karnataka soaps and detergents was ordered, my lord. They have now come on record, my lord.
There is a delay of 217 days.
Please,
217. PA number 1 of 24. Prayer in this interim application is to condone the delay of 217 days, which has taken place in filing the appeal. The appellant is state government. The appeal is directed against in order of learners where dated so and so soon. Judgment and order learners dated kind of 26 September 20. Related to the grant of pensionary benefit, the petitioners. the aggrieved state SL and the state judgment in order. Paragraph. The delay of 217 days has been explained in the accompanying affidavit filed by the Undersecretary to the Government from Commerce and Industries Department, in which it is literally stated that where is your F? It is there.
Please,
Where is your affidavit in support of delay convenience? Clearly stated that after the writ petition is allowed on 26/9/23 by law in a single day, directing, setting aside the impugned order dated, impugned endorsement dated 28/7/21, and requiring the refixation of the pay, the Directorate of Industries forwarded the copy of the said order and said order asking the state government to take further action. Thereafter, opinion of the Finance Department was asked for. File was sent on 7/11/23. The Finance Department, post of the Finance Department gave its opinion on 12/3/24 and advised the Administrative Department to file writ appeal. It is stated that thereafter the decision to file the appeal was communicated to the office of the government head office, and appeal was prepared and filed. It is in this process that delay of 217 days has taken place. The appellant is a state which is impersonal body. Most of the reasons indicated leading to passage of time and the resultant delay are administrative in nature. Since the appellant is state government, consumption of time is inherent to to an extent in the decision-making process. Viewed from above considerations, viewed from the standpoint of above considerations, it could be said that sufficient cause is made out to condone the delay of 17 days. Delay is condoned. Application is allowed. Now, appeal will take up to or any other day.
I'll leave it to Akshay, my lord. They have come on record.
We are ready, my lord. And we are submitting the written submissions.
My lord, I can make my submission. Can make my submission, my lord. I will leave it to your lordship. Lord, the matter relates to fixation of pension, my lord.
You want time?
Yes, madam,
Respond number 1, 2.
please.
You are respondent
Represented by
number
learned
one.
advocate Miss
Shivarudrappa Shetkar, madam, on behalf,
so and so, so and so.
please.
Takes
Respondent number 2,
time, takes time.
please.
As learned
One
counsel wants-
week time.
Wants to file wakalat.
Yes, madam, please.
When shall we keep?
Please, madam.
When shall we keep?
And shall we keep on? We are ready.
Your date.
When do you?
Tell your date.
Sorry, any date, madam, please.
Third April.
Next week, any date, madam,
But they
please.
are filing a written synopsis. my lord. They are filing a written argument, my lord. If they can share it with us, we will be able to assist the court. They are filing a written argument in the matter. If they can serve us a copy, my lord, we will be able to assist the court.
Yeah.
Due copy.
Please,
3rd April.
please, madam.
It's number 22 to Shailesh.
Please, sir. Delay of 7 days. Everybody is
So the respondent number 2 is.
I appear for the appellant, my lord. My lord, may kindly have this matter tomorrow, since my client is unable to attend any meeting.
1st April.
Not tomorrow, my lord. Tomorrow, personal inconvenience.
We're not keeping tomorrow. 1st April.
Much.
As requested on behalf of the appellant.
This is number 23. Stanley Shanta.
For the appellant in this matter, my lord, there is a delay of 166 days, my lord, for preparing the appeal, my lord.
So anybody is appearing?
There is a delay of 166 days.
Other side is appearing?
No, more that, notice was served, more that, no. Notice was served, more that.
So
PDA, more that. Notice was served, more that, no.
government
represent-
advocate for R3, special enacted is R2. All are served. All are served?
All are served, more that, all are served.
Full stop. IA number 166 of, are you appearing? Anybody appears from the government side? 23, 23.
Three, my lord. I'll appear, my lord. for it.
You will appear?
For respondent number 3, my lord.
This one, 2,
3, my lord.
3. So, who is 3? Chief Secretary. IA number 1 of 24. This is an application for condoning delay of 166 days, which has occurred in referring of the writ appeal by the applicant appellant. Respondent number 1 and 2 are served. However, they have not chosen to appear. Also, learned additional government advisor, Mr. Harish appears for this one 3. Full stop. Give copy to the council.
Please, more that.
Give copy to the council.
The panel,
NL. Give. 17th. 17th you give. On that day will count on that.
please, more, please.
To be listed at 2:30 on 17th.
Number 24, Sri Chetan.
While the writ petition for mandamus, my lord, there is a government land which was reserved for Dhobi Ghat. But seventh respondent has encroached and has put up a structure there. The writ petition has been dismissed on the ground that there are factual, but actually there is no factual, the facts are correct, my lord, there is no difference. And learned single judge had directed the government to get instructions, and government submitted, it has been granted to the seventh respondent. But actually no such grant is there, madam. But they submitted before the learned single judge that it has been granted to seventh respondent. That order.
The lordship may grant me some time to secure instruction, my lord.
2nd April.
Number 25, AMC Basuraj. Number 25, Basuraj.
Keep it.
Number 26, D Basuraja.
And for the respondent, petitioner, my lordship.
For the respondent.
I am for the petitioner, my lordship.
26. So we'll count on the delay of 53 days.
Lords, with condonation, I have no objection. Insofar as the IFO stay is concerned, I'll file my objections.
File it. We'll keep it on 3rd of February, 3rd of April.
Madam, name 27 is urgent, number 28.
Lord, I appear for the appellant, my lord, in 28. Lord, on the last occasion, my lord, learned counsel for RBI, my lord, took notice in short time. While your lordships heard me, my lord, on one point, there's another point, my lord, which would have to be urged. Meanwhile, my lord, I have instructions to submit that our client is trying to see if there is some via media settlement possible.
Not possible. But this is that matter where there was a stay order against the NCLT on the ground of classification of account. Thereafter, the writ court noticed that interim order had been granted on a factually incorrect submission because that classification.
There's no interim order operating, my lord. I don't see how it should prejudice my learned friend, my lord. There is no interim order operating. Your lordships are not granted an interim order.
Fraudulent.
Yes. I made one allegation against the result.
But the.
On the last occasion, it fell from the court that this court was inclined to dismiss the appeal.
But my lord, I had,
You are really trying for settlement.
yes, my lord, I'm keen on settlement, my lord. In fact, I have got, my lord, the demand draft for 40 crores is ready, my lord. I've even filed a copy of it. My lord, what happened was there was a settlement that was arrived at through a mediation.
Lord, anyway, proceedings are going on at the NCLT. They also have a writ petition pending. This is a writ appeal against an interim order. This appeal need not be kept pending here. If at all my learned friend is keen to settle, he can always approach us before the NCLT or in the writ court also. This court, there's nothing survives.
No, my lord, there is one aspect, my lord, which I had argued, for which Reserve Bank had to respond. I had said, my lord, I had sought an interim prayer which was granted initially and later vacated, that Reserve Bank must take action against this first respondent. On that aspect, my lord, the Reserve Bank, my lord, has to be heard. I have to make my submissions on that. I'm only saying, my lord, no hardship is caused to anybody, because the interim order granted by the learned judge was not continued, and your lordships have not granted an interim order. So if the matter can be settled, my lord, we'll make one attempt. That's all that I'm saying.
My lordship, they have not prayed for such relief in the writ appeal. They can plead the same in the writ petition. Whatever they're asking from RBI, that is a prayer in the writ petition, not in the writ appeal.
No, it's a prayer in the writ petition.
In the writ appeal, sir.
And there is a prayer in the writ petition, and there is an interim prayer in the writ.
No, they, in any case, they want to make an attempt, endeavor to settle. Let the 10 days.
They have entered into settlements earlier and broken. Their conduct has not been bona fide at all.
We grant one day. Mr. Nagananda, not beyond 1st of April.
Grateful.
Please, please.
Grateful.
Case number 29, Arjun Rao.
Hearing for the appellant, my lord. My lord, the arguing counsel is traveling at the moment. I seek a week's adjournment, my lord. We have to file an additional affidavit to bring on record the judgment of the DRT in this matter.
You are for?
Appellant, my lord.
I am for the respondent number 1.
So you want time?
Yes, my lord, a week's adjournment.
We'll go to 7th April.
Pardon?
7th April.
Yes.
Public. Case number 30. Sunaina Basu Malik.
Petitioner's counsel. Chips had heard this matter and an interim order had been granted.
Lord, this may be called after 3 weeks, my lord.
The power of the petition committee, my lords, to direct, legislative petition committee to direct stay of mining operation. That matter. Was committee has been served but unrepresented. I'll leave it to my lord. The detailed interim order itself traces, my lords, our contentions 23, 10, 24.
You have not filed reply?
No.
My lord, based on the directions of respondents 2 and 3, my lord could grant me 3 weeks, my lord, to see if we can resolve it, because they have been served and they are unrepresented.
Based on the recommendation of 2 and 3.
Respondents 2 and 3.
Petition committee. They are served and unrepresented.
Yes, the senior geologist was constrained to issue a letter saying that, my lord, their crushing activity should be suspended, my lord, till a survey report is done. My lord, since it is at the instigation of respondents 2 and 3, my lord, if my lord could grant us some time, my lord, I'll request the learned advocate general, I'll seek instructions and make my submissions.
at the request of learned additional government advocate, stand over to 15th of April.
Obliged.
15th April.
Please.
Interim order granted earlier shall continue to operate. Please. Full stop kar de. Continue to operate. Full stop. Yes.
It's number 31. So my address.
I appear for the petitioner. The challenge is to annexure A, Lord, passed by the senior geologist. We only on the basis of the legal opinion. Lord, he passed this order. May not be.
My lord, may I make one submission, my lord? My lord, to resolve this issue, considering that there was some misunderstanding by the senior geologist that when the application of the petitioner had been disposed of, my lord, the senior geologist understood it to be as rejected. My lord, if the matter could be, my lord, remanded back, my lord, so that the application of the petitioner could be considered in accordance with law. My lord, I've kept the officer also present. It's at his instructions, my lord.
That translation is may not be appropriate. Lord. May I pass on the translation?
To be sent back.
My lord,
Send back. To be sent back.
yes, my lord, may be remanded. I've kept the
What is
senior
this?
geologist.
That's the impugned order.
So it is not properly translated.
Translate. That's why.
So which part is irrelevant?
The last param, Lord.
In view of the above, since the case is subject
Yes,
is found the compliance with the legal sales opinion is necessary. Proceeding with the applicant's file at the stage of deemed unfeasible. Yeah.
in fact, this is a very detailed order passed by the senior geologist. However, his hands are tied because of the legal opinion. Even that legal opinion was rendered based on the improper facts submitted to the legal part. That also. In any view of the matter, Lord, competent authority has to take independent decision.
My lord, the ground at paragraph 29, violation, they have not been given an opportunity of hearing.
So we'll say that the legal opinion is weighed with the, only ground of legal opinion is weighed with the
Yes.
Yes,
senior geologist in rejecting your application.
Yes.
Therefore, it shall be reconsidered in accordance with law on merits
Please,
based on the material available with it.
please.
my lord, and the fact that they contend that, my lord, an opportunity of hearing was not given to them, which they themselves say at paragraph 29 of their grounds, page
Since
18.
it has been remanded, that
So it's
question
a-
would not
since one of the
arise.
ground is opportunity hearing.
Yes, yes.
We'll give an but main ground is this, both.
Yes,
Within
my
12,
lord may fix.
within
How much time?
12.
My lord, yeah, he says 4 weeks, my lord may
12,
grant us
12,
8,
12 weeks,
12 weeks, I'm obliged.
12. Will you pass the
Please.
Obliged.
disposed to in today's district.
Cell number 32, the Raghavendra BS.
My lord, this is IA of 2024 regarding the order dated 19/3/2024 for the DNP, my lord, dismissal of non-prosecution, my lord. To recall the order dated 19/3/2024, my lord. We have filed the IA to recall the order dated 19/3/2024 to recall the dismissal order, my lord, dismissal for non-prosecution. What may be allowed, my lord? We'll compare the office submission in a week, my lord.
Which order to be recalled?
19/3/2024, my lord.
Application is there, but where is the order? IA 1 of 24. This application is filed seeking to recall order dated 19th March 24, whereby 3 weeks time was granted for removal of office objections, telling which the contempt petition was to be dismissed automatically since paragraph. Since within the stipulated time, the office objection was not removed, the contempt petition was stood dismissed. Therefore, this application is filed in the larger interest of justice and in order to enable the applicant appellant to this petition. What is this? Applicant petitioner to contest his contempt petition on merits, comma, the order dated
19/3/24.
so in 19/3/24 is recalled, comma, contempt petition is restored to its original file on condition that whatever office objections are left out to be removed, comma, they shall be removed within 2 weeks from
1
today.
week.
Within 2 weeks from today.
Grateful, my lord.
Cell number 33. Vetanand.
Appear for the respondent, my lord, in the writ appeal and petitioner in the writ petition. My lord, strictly, my lord, the writ appeal may be separated, my lord. It is an individual grievance, whereas the writ petition, my lord, is a public interest. My lord, your lordship may independently hear that writ appeal, my lord. My lord, in the writ appeal, my lord, the difference of pension, my lord, is a few hundred rupees. My lord, they were getting around less than 500. Their claim was about 1,100 or 1,200 per month. That is the dispute. My lord, several writ petitions were allowed, special leave petitions were filed.
For
All
you are filing PIL.
Yes.
PAL is different, my lord. It is totally different.
Huh?
That they may be,
Both are PIL.
not my lord. The first is the writ appeal, second is the PIL.
Writ appeal is filed by the EPFO challenging the order of the learned
Learned
single
single
judge.
judge's order.
But,
Where is the writ appeal? Where is the order in the writ appeal?
Writ appeal, my lord, your lordship may kindly see. My lord, page number,
3071.
page 10, my lord, of the writ appeal.
3021. Which is the order?
My lord. My lord, your lordship may kindly turn to my lord, page 18, my lord, the page 17, para 4. May I read it, my lord? Heard arguments on both the sides and perused the entire writ papers. Similarly placed employee by name Chennakeshwulu approached this court in WP so and so. This court by order dated so and so disposed of the said writ petition, holding that he has entitled for more pension by interpreting para 12(4)(b). Learned counsel for the respondent Sri so and so contended that the claim of the petitioners in these writ petitions falls under para 12(3) and 12(5), and the same was not interpreted by this court in Chennakeshwulu's case. Therefore, the benefit extended to Chennakeshwulu cannot be extended to the petitioners, as they fall under different category. There is some force in this contention of the learned counsel for the respondents. Therefore, I hold that the petitioners are not entitled to the benefit extended to Chennakeshwulu by this court in so and so. It is not in dispute that the petitioners retired prior to 15/6/2007, the date on which amendment to the employees' pension scheme was made. Under the unamended pension scheme, the petitioners acquired a right under para 12(3) and 12(5). This accrued right under the unamended rule cannot be taken away by the respondents by subsequent amendment dated 15/6/2007. Therefore, I hold that the petitioners are entitled for the pension as per the unamended para 12(3) and 12(5) of the employees' pension scheme. In the impugned endorsement, the respondents have fixed the pension of the petitioners under unamended pension scheme, and therefore the same cannot be taken away by a subsequent amendment. Even if the amendment is insertion, the same will not affect the rights already accrued to the petitioners.
Oh, they have decided the representation.
No, my lord. They preferred writ appeal, and writ appeals are pending.
Yes, this order they have preferred.
They have preferred writ appeal.
Where is this order?
Yes, my lord.
Where is that written? This very.
The very writ appeal is against this order.
this is a writ appeal matter which they have filed.
My lord, hundreds of special leave petitions, my lord, filed throughout the country. All the special leave petitions, my lord, were dismissed. Maybe in thousands, my lord, not even in hundreds.
Even the order is not post. Without posting order, the direction is.
My lord, appearing behalf of my senior Shweta Anand, she is held up on quota number 4. Kindly pass over.
This is of 2015. Well,
Quota number 4.
It is of the year 2012.
who appears?
Shweta Anand.
Shweta Anand.
Petitioner, Shweta Anand.
Shweta Anand.
Mrs. Shweta Anand, my lord, is representing the appellant.
Pass over.
Your lordship may have it tomorrow, my lord, in that event. My lord, I have a matter in the afternoon before court hall number 2, my lord. Your lordship may kindly have it tomorrow, my lord.
You come after finishing your.
Please.
Number 34, Nanjareddy
Here, for example, the complaint affidavit has been filed, my lord, and copy is also served on the complainant, my lords. And I received just now, my last year, I have next week, my lord, I received the copy now.
Third application.
Number 35, Mr. G.R. Mohan.
This matter, lordship, pertain to the Malatali Lake encroachment wherein they are supposed to close that amphitheater, they call it as Kalyani. So they are asked to file an additional affidavit. That's what the lordship, last occasion we
Filing
submitted.
the additional affidavit, my lords, wherein the Kalyani will be used only solely for the purpose of Kalyani and not as an amphitheater.
In fact, on 26th also they conducted in the use this as an amphitheater, and huge loud music, everything was played, you know.
So this is contempt.
Yes, my lords.
So what is the order? Which is the order?
Contempt is pertain to your lordship.
But since on the last occasion,
Which is the order not complied with?
Page number 38, your lordship, the order of the annexure D,
38.
page number 38. The directions were issued by the Samal Court is at page number 55, your lordship. 55. There are 7 directions. The authority shall ensure that there shall not be any temporary or permanent construction or commercial or recreational or industrial activity, and there shall not be any pollution or conducting of any act which is disturbed directly or indirectly to the tank or tank bed area. The authority also shall not permit any individual or any group or any political party to use the tank area for recreation and celebration. So also ensure the protection of the tank as admitted by both the parties. Since the total area of the tank is 71.18 acres, except the dispute with respect to 3 acres as stated supra, which is pending before the court. The water spread area of 42 acres, which is now increased to 44 acres, should not be allowed to decrease, and that shall ensure that no individual group or political party shall be allowed to construct any permanent structure within tank area of 71 and or to pollute the water. Now they have put up all the construction for the purpose of the Shivaratri festival, which is every year they are repeating it in spite of the order of this court on 20. Then the authority shall ensure that the Kalyani is cleaned immediately after the festival of Ganesh, Durga and traditional rituals of Chhat Puja, and ensure that water in Kalyani shall not merge with the water tank. The authority shall ensure that the granting permission or immersion transfer shall not constitute to misuse for any other purpose. This is what the authority shall not grant permission of putting up inside any permanent or construction inside the water. And based on that, the photograph which are produced, your lordship, it shows that it is an amphitheater. That is what they stated in their affidavit also by the respondent commissioner. So last occasion it was also they closed that because it is they want to use it as an amphitheater, which actually disturbs the birds and everything will be there in the lake area. So that is the intention of this court to and not to give for recreation purpose. Yes.
Lords, in the affidavit which I filed today, my lords, at paragraph 3, my lords.
Now, one submission, lordship. No, they are saying that amphitheater, lordship. Your lordship, look at the photograph, the last occasion which you have produced, also along with the memo. It is, they have kept it open. It should be closed, your lordship. To call it as a Kalyani, water should, for storage of water, it should be closed, your lordship. Kindly see the photograph, your lordship, which I produced last occasion. If your lordship look into it, it is kept it as a open, to use it as a amphitheater.
Come to para 3 of the today's affidavit.
I agree. I am not disputing that they say, but it should be closed. That's what my responsible submission. It is not closed. Even today it is open, your lordship. But use it as a Kalyani to storage of water for purpose of immersion of any idols and everything. It should be closed. That is not closed. That is my responsible submission. That is what the last occasion your lordship suggested.
come up with they have not said that.
Para 4 is there.
No, that is not something to not this, this is some other area, some other portion that in that. Because mesh they put, now they will put the grill and other.
It's substantially complied, sir.
Yes, sir.
Substantially.
Now, only thing is that they have to close it, that they are not making it.
Please pause.
That's all the thing.
Grateful, my lords.
If they close it, it can be closed. That's right. They have to just, they kept it open, your lordship. That is the only concern we are. Again, they are using it for the functions because they say that amphitheater also as a Kalyani. Again, the dual word, they used it in the subject also.
If it is,
So
so
your lordship look into the photograph, your lordship.
again, file another petition.
Number 36.
Great.
Shadi Narayanappa.
The direction is change the revenue records from father to son by considering a representation within 3 months.
Yes.
My lords, to that effect, my lords, the complaint affidavit is filed, my lords, stating that it is an Inam land, my lords. Lordship, may kindly see para 3 of the order passed by the learned single judge, my lords. Page number 11, my lords. The grievance of the petitioner is to consider the representation dated 9/8/2023 seeking change of revenue entries in view of demise of his father. To that effect, my lords, an endorsement has been issued, my lords, now with the reason stating that it is an government land, my lords. Nothing is expressed on the merits of the case, my lords, and endorsement has been issued R1 and R2, my lords. To that effect, a complaint affidavit is filed on 23rd July 2024, my lords.
Earlier, revenue record stands in the name of my father. My father to change the revenue records into my name without there being any objection from any person or any order from the heir authority. His own order is violated and the accused number 2 himself is a passed the order in earlier occasion.
So it is considered, representation is considered.
Okay.
What more? 19/7/24 order. Same order.
Please, my lords, 97.
But his own order in the writ petition, I have filed the accused number 2 order, where he clearly stated that how he is entitled for changing of revenue records and changes the revenue records.
That is in the realm of merit. The only direction of learned single judge contained in order dated 4th December 23 was to direct responsibility. Tehsildar Mulbagal to consider the representation dated 19/8/23 within 3 months. By the state representation, the petitioner was seeking change in the revenue records in view of the demise of his father. Also, the compliance affidavit filed with respondent indicated that the representation was considered and pursuant thereto, the endorsement dated 19/7/24 reflecting the decision has been issued. Copy of the said endorsement figures on the record along with the compliance affidavit. Page 6, annexure R1. In above, the present contempt petition does not survive, it is accordingly disposed of. If the petitioner is Agreed on merits in respect of the endorsement passed as above. It will be open for the petitioner to institute independent appropriate proceedings before the appropriate forum, in respect of which, however, this court does not express any opinion on merits.
Yes, number 37. View Anil Kumar.
Complaints affidavit is filed, my lord, to that effect, they have filed a rejoinder, my lords, to the complaints affidavit. In this complaints affidavit has been filed by my lords, to that a rejoinder has been filed by the complainant, my lords. I need to secure some instructions, my lord, pray for 2 weeks' time, my lords, to.
So while allowing my petition, division bench, my lords, at paragraph 40 of the order, which my lords would get at page 102, had specifically directed that seniority, the deemed dates of eligibility in the feudal cadre have to be set right by adhering to the quota rule in accordance with provisions of Rule 2 of the.
Points time. At the request of learned additional government. 10 or 21st April.
Number 38. Amit, Xavier.
Appear for complainant, my lord. So complainant not received certified copy. Complainant not received certified copies.
Which certificate?
This
Which
one,
certificate copy?
My lords, in this matter, the grievance of the complainant was that, my lord, they had applied for certified copies of production of 5 documents, my lord. To that effect, my lords, and complaints affidavit is filed, and we have given the certified copy stating that 4 documents are available, 1 document is not available, which is not available in the records. That is a part of the complaints affidavit in my lords. I filed it on 4th December 2024, the complaints affidavit, my lords. And all the documents have been furnished, my lords.
in this matter, we had to certified copies we had to share to them, my lords. 2 days time may be given, my lords. We will. My lord, please provide tracking number. So I complainant means I can track the copy will.
2nd April.
Number 39. Paksha PH.
So the direction of the learned single judge, my lords, is at page 26, my lord. So it's at para 9, my lords. The respond department, my lords, was directed to continue the petitioners, my lord, as scavengers, my lord, till regular recruitment, my lords, is undertaken. We had filed a representation, my lords, requesting them, my lords, to, in fact, a writ appeal was filed, my lords, challenging the order of the learned single judge, my lords. That writ appeal was also dismissed, my lord. We requested, my lords, the respond department, my lords, to continue as in service, my lord. However, till date, my lords, now, my lords, it appears they have filed a compliance affidavit. However, a copy, my lords, has not been served, my lords.
So,
Copy is furnished, my lords. My lords, till date, my lords, the order of the learned single judge, my lords.
16th April.
Appear for the complaints in this case, my lord. We are withdrawing the petition. My lord, accused is no longer the commissioner of the MUDA, my lord, and the order has been partly complied, my lord.
Which order? You are doing.
We are withdrawing with liberty to file a new.
Learned advocate.
Liberty may be preserved, my lord.
Present contempt petition by filing memo dated so and so, which is taken on the record. The petition is dismissed, dated, handwritten memo dated 6/3/25. In view of the memo, it is not complied with.
Partly
No.
complied, my lord. Partly complied, my lord. Liberty may be reserved, my lord.
No such qualified withdrawal. Full stop. Learned advocate, none. Honor advocate. So what is the order?
It's not in blood. He was transferred.
Order is passed
He is
by,
no more the commissioner
any order is passed?
and no order. Blood. The commissioner, the accused here in blood has been transferred. Blood. It's 4 months back.
So he's saying that.
Not
So you wanted to transfer the.
last
commission?
occasion. He took time to blood.
How
impede
it is
the present
partly complied
commissioner.
with? You wanted to transfer the commissioner? Then how can you say it is part? In what way it is partly complied with?
Those 4 acres, 32 guntas was allotted.
Not complied with?
No, because the accused here in blood was transferred in the year.
Are you making statement it is complied with?
No, it is as
He is not saying
That
you are
my-
saying complied with.
instructions are concerned.
But reverse situation. 23rd April. You come with proper thing, wasting the time of the court, yes.
41.
I appear
Jai
for
Kumar.
A1 and A, accused 1 and
My lord, my name is Dr. Sanjay Kumar Vaishnav. I am the party in person. So this case is very clear. Auditors, this.
Has been actually complained, my lord, so he is not happy with the complaints order.
Yes.
Therefore, he has filed a contempt petition.
if you may see Annexure B,
Yes, it is a good case for a fresh writ petition, whatever he wants to file.
No, my lord. Reason is that the CAG is saying rule number 8 CCS RP rule number 2008 fixation of the pay of the fresh requirement on or before 2006. But my case is not the fresh requirement. My case is the regularization. You can see the page number 61 as approved by the Government of India. Sorry, 69. Page number 69, the letter kindly refer to the recommendation of the committee on the regulation of the temporary support staff of the Center Liquid Research. I am the conveyor of the approval of the competent authority to proposal. You may kindly make necessary arrangement for implementation of the recommendations.
Services are regularized.
It's very clear.
his service is regularized, we are not saying anything. But as per the directions of this, of the court, we were supposed to pass appropriate orders.
You are number 4. You are number 4.
1 and 2, 1 and
One and
2.
You are 1 and 2.
He is for number 3.
I am for 3.
Their reply has been given, if you may see in page 20 of the contempt petition, is what they have written. Then thereafter, we pass the order, which is on Annexure B,
So my
which is
lord,
on page 17.
this is no
You
rule.
may please see. If he
Because-
has any grievance against the order which we passed appropriately, he can file another writ petition. We have not done anything.
Where is your?
No, my lord.
Page 17 of the contempt petition, Annexure B. I've also put a memo of compliance, which is the same thing
My
I have
lord,
done.
they they clearly said 20th representation given by me on 20th, 20 and 22. They should be
As per the
appropriate
direction-
order in the accordance with the law. So law says as per the CAG, CCR rule 2008 is applicable only fresh appointment as they submit in the court,
That
my
is-
lord, this honorable court. And my case is not the regulation. Sorry, my case is the
R1.
regulation.
Page of your,
I didn't,
page of your memo.
my memo is on page 2.
No, memo is what? Page 7?
No, on Annexure 1, page 2 of my memo of compliance.
R1, R1.
R1. I am for Center for Nano.
5 to 24.
Yes, ma'am. I have complied in detail order I have passed after,
Me.
after
are-
consulting him, which is on annex.
You are Director Center for Namo.
Yes, and they have given in page 5. That is 3, page 5 of my memo, if you may see, which he also has produced in his petition.
Yes.
All
But
these what I have
no,
produced
my-
in the memo is
my
being
simple-
produced by him in the petition.
Simple question, sir. My simple is very clear that my case is
He's not
regulation.
happy with the order we have passed, that's all.
Correct, madam. But reason is that as per the order of this honorable court, order says according with the law. So my case is not applicable, my case is not come under CCR rule 2008, which is says you saying both the cases report as well as the affidavit that the only fresh requirement is applicable. So reason is here, you can see, my lord, this page number, I will tell you. Last accommodation, they make the report in the our administrative officer, his para also is not dropped and he is not the supernation. So his para is not dropped and he is supernated without any problem. So they are using me as a gun
or whatever you can say like that. So they want to harass me basically, because my case is very regularization, fresh. It's not the fresh case, and our service consider our service on contract 50% of the service for our pension as well as the future promotion and all the thing. So how can you say that CC rule 2008 is applicable on me? When in this honorable court is passed the order, this very clearly says 22 recommendation you have to be considered within the law.
The granting of some increment.
No, sir. Yeah, reason is that during my regulation, they given the 2 increments, which is
Yes.
so during my regulation, they given me the 2 increment because on our service also considered for the previous service considered for the future promotion and retirement benefits. And during that whatever 5th CPC and 6th PC's transition period was there. So during my approval, the 5th CPC was there.
While disposing of the writ petition by order dated 25th October 23, learned single judge directed discipline 1 and 2 to consider the representation of the petitioner dated 22/20 and 4/2/2022 and pass appropriate order in accordance with law. It was observed that it will be open for discipline 1 and 2 to consult discipline 4 regarding fixation of entry pay of the petitioner, having regard to the fact that the service of the petitioner was regularized and it was not a case of press appointment. Before the learned single judge, the prayer of the petitioner was to restore 2 increments of the petitioner by fixing his pay
From 2009 onwards.
in pay band of rupees
93. 93.
You want to pass the order?
No, sorry.
Please sit down. Please sit down. 9300 to 34,800. Full stop. In response of the present contempt petition filed, alleging non-compliance of the aforesaid directions, respondent number 1 and 2 have filed their compliance affidavit. Their memo of compliance dated 9/1/25, along with which the order public endorsement dated 5/2/24 is produced. In which it is stated that the increment cannot be restored to the petitioner. Full stop. In view of the above endorsement, the above endorsement marks compliance of the directions of learned single judge. Nothing survives in the present contempt petition. It is observed that if the learned party in person has any grievance about the merits of the endorsement, it will be open to the petitioner party in person to institute appropriate independent legal proceedings as may be permissible in law, in respect of which this court, however, does not express any opinion on merits. The contempt petition is disposed of accordingly. Has not ended. Yes.
Bill number 42.
My lord, with your permission, can I give something, sir? Sir, can I request, because this petition is, can I get the increment?
Pardon?
Can I get the increment or?
You have to file separate proceedings. This is a contempt proceeding.
So contempt, but thank you.
My lord, in serial number 42, I pray for the honorable court's some more time, my lord. In the meanwhile, writ appeal is filed, my lord. The honorable court was pleased to issue notice in that matter also, my lord. The compliance, my lord, I humbly pray for some more time. And writ appeal is pending for consideration. Your lordship heard me and notices were issued. It is pending for consideration. Please.
Kindly see page 11.
Kindly,
Only
ma'am.
for a minute. Only one minute.
Memo is
The
filed.
order passed in the writ petition is at page 11. And this order was passed.
Is filed, writ appeal is filed.
Please, the Honorable Court heard me and notices were issued also. My lord, writ appeal number 262 is pending. Kindly, my lord.
By us,
Please, my, your lordship heard me and issued the notice.
released, then we have.
No,
Please.
may only one request. Now, kindly see the order dated 8/12/2023. It was based on an undertaking given by the respondent principal. Where is the question of an appeal?
Bill is filed, then we have issued no.
No, well, kindly see para 4 of the order
Yeah.
at page 14. Page 14.
Hmm.
At this stage, Sri so and so learned counsel for Shimoga Corporation submits. The corporation has not prohibited the petitioners from carrying on the trade of meat in Shimoga, but the requirements under the applicable law will have to be fulfilled. Insofar as the slaughterhouse is concerned, no slaughter can be carried out within Shimoga Corporation. Since no abattoir is established, he submits, if the application of the petitioners is restricted to trade, the same would be considered by imposing necessary conditions to save. We have given an undertaking, we are not slaughtering any cattle in Shimoga city.
You are not.
We are not slaughtering any cattle in Shimoga.
My lord.
We are importing the
You are for corporation.
Please,
it's
my lord.
based on an
Your
undertaking.
lordship heard me, my lord, and notices were issued. Kindly, my lord, one opportunity. Kind.
When it is coming up,
My lord, it is, my lord, listed on 1st April, my lord.
first to be listed in first.
No,
Please.
5 years we have no source
they
of
will-
Kindly, my
livelihood.
lord, one opportunity.
They have appeal is pending, we can't enforce.
Please, my lord,
That will see in appeal.
With great respect, when it is an undertaking given, how can there be an appeal?
That's an argument in appeal, not in contempt.
please.
With great respect, what we should consider
We'll
that we are
consider-
without any livelihood for 5
Sir, we
years.
consider on first, where is the question?
Sir, another 6 years you want to prolong?
1st of April, no?
Yes, sir,
Please,
it will go to the next year.
No, it will
It
not.
is.
Why?
Because we have stopped the business way back in 2020. And since then, uh, an incorrigible officer is
Can't-
refusing to give license.
We can't make the appeal infructuous by granting relief in this contempt. To be listed on first along with the writ appeal number so.
Please.
Court officer.
May I make one submission? Serial number 62, Your Lordship, has
Thirty-
become infractuous.
32.
Yes, 62.
Learned advocate Miss so and stated for complainant.
Appellant. 62.
62. Learned advocate Miss Mamta G. Kulkarni for the appellant stated that stating that the appeal has become infructuous, files memo in that regard. The memo is taken on record. In view of what is stated in memo and in view of the statement made, the appeal is disposed of as not surviving, having become infractuous.
Much of.
All interim applications stand disposed of in view of the disposal of the main appeal.
The list number 2 for pronouncement of judgment is seal number 1, writ appeal 160 of 2025.
For appellant, my lord.
Respondent.
With no confidence motion. Appeal is dismissed.
List number, seal number 2, writ appeal 1374 of 2024.
I appeal for the respondent, my lords.
This appeal is allowed and ordered in 30/10/2023. Passed by the learned civil judge in WP number 50371 of 2018 is hereby set aside and writ petition is hereby dismissed.
Passover matters, seal number 25. Seal number 25.
None was present on
MC
behalf of the
Basuraj.
appellant, even in the second call in the second session. It could have been, the appeal could have been dismissed for want of prosecution, however, in the larger interest of justice, to be listed on 17th April.
Seal number 33. Ms. Shweta Anand.
I appeal for the petitions.
So, who is Aman Kumar? Okay. He was to take instruction. He's not there. We'll adjourn it. In view of the order dated 18/3/24, absence of presence of learned Central Government Council, Mr. Aman Kumar was awaited in vain. Full stop. Send over to any urgency. 21st of April.
Matters. 230 matters. Seal number 78, withdrawal of contempt to VB Sidramaya. Complaint in this case, ma'am.
Withdrawing.
Please, madam. I filed a memo for
Learned
withdrawal. This case,
advocate,
madam.
Mr. What is your name? VB Sidramaya.
Please, madam. My senior name is madam.
What is your name?
Maunesh SB, my lord.
So and so, so and so. For the complainant, files memo dated 4/3/25 seeking to withdraw the present complainant, stating that the parties have settled the disputes In view of memo and any of the statement, contempt petition is dismissed as withdrawn.
Grateful. Case number 79. Kumar Swami Remat. 79.
Posted yesterday, my lords. Matter was posted yesterday, my lords.
Yesterday, the following order was passed by the court. Yesterday, that is on 5/3/25, following order was passed by the court. Quote the order. Today, when the petition was posted, today the petition was posted at 2:30, especially to give opportunity to the advocate, learned advocate for the petitioner to remain present in light of the what is recorded in the order about the compliance having been already obtained of the order under contempt. None is present. Full stop. Since the order is complied with as per the statement of learned additional government advocate, the Raghavendra, the contempt petition is disposed of as not surviving. In case of genuine difficulty, liberty is reserved for the petitioner to revive the petition by filing a note to the register. Yes, next.
Number 80. Mr. Ranganath S. Joyce.
In this
Number
matter, my
80.
lord, I'm filing the compliance affidavit, my lords.
Yes,
Filing compliance affidavit, my lords.
learned additional government advocate, Mr. Raghavendra files compliance affidavit. None is present for the petitioner. The affidavit is taken on record. The petition shall be next listed on 24th April.
Case number 81. Mr. Venkatesh Dalwai.
My lord, in serial number 81, my lord, I'm filing, my lord, a memo along with the government order, my lord, pertaining to withdrawal of the government order which is impugned in the writ petition, my lord, wherein 2 acres of land that had been gifted had been handed over to the Minorities Welfare Department. Lord, actually, 2 orders have been passed in one order, my lord.
It's impugned order is at annexure K. But the translation version is at what page 196, annexure K1. Which was
My lord, I'm
impugned.
filing the memo.
$196.
I'm sorry,
There is no
186 marks,
186.
186. This was impugned before a lot.
Withdrawn.
Yes, we are withdrawing the government order.
I'm very grateful for the government. That's only one request I wanted to make. My lords. Yes, we have. Second prayer in the writ petition. These two, my lords, subject to your lordships, what falls from your lordships, my lords, I leave it at that. Lords, I have sought for annexure, implementation of annexure F. Annexure F is some of the facilities which government already, my lords, wanted it to establish in the property. Page 160,
If Lordships will kindly come to page 160. This is a report of the Commissioner from Animal Husbandry and Veterinary Services Department. In this land, they propose to establish, page 163, my lords, certain facilities for in consonance with the veterinary hospital, district office, liquidation oxygen plant, district animal medicinal ground, go down, farmer training center, and so on. So my lord, this, if lords, they can consider for establishment. This is part of their communication only. I'm not John Mayer. While rejecting the previous request, this is how the government decided to do it. This is reserved for these purposes, therefore we cannot give it to somebody else. So Lordship,
It's an interdepartmental communication. I wouldn't know what has
I have
happened.
taken under RTI, I leave it at that. If they can implement it, it's well and good. Ultimately, my lords, it is nobody's benefit. It is for the farmers and the veterinary hospital.
The petitioner who
Now then I'll have to take instructions as to whether, my lord, office is there of the deputy director.
There are RTI documents. My friend can peruse the Kannada version.
No, this may have taken effect, this may not have taken effect. So I wouldn't know, my lord.
the petitioner who pleaded himself to be the social activist and an advocate by filing the present petition in the nature of public interest petition. Firstly, prayed to set aside the order dated 26/2/2024 passed by the Department of Animal Husbandry and Fisheries, Bangalore. By the said order, the land belonging to the Animal Husbandry Department in Chala Padi, Palya, Port 2, Chamarajpete, at measuring 2 acres, was decided to be transferred to Minority Welfare Department. In the order, it was recited inter-alia that the Honorable Minister of Housing, Wakaf and Minorities Welfare had opined for such transfer. Therefore, the transfer of land for the purpose of minority welfare was effected. In the course of the hearing today, Governor Additional Government Advocate Srimati Neelofar Akbar filed a memo dated 6/3/25, along with which produced was the proceedings of the Government of Karnataka containing order dated 4/3/2025. Whereby it is decided to withdraw the aforesaid order dated 26/2/24. The memo is taken record along with the copy of the withdrawal order dated 4/3/25, produced in vernacular as well as with English translation. In the aforesaid view, the petition does not survive inasmuch as the aforesaid prayer was the main plank of grievance of the petitioner, which stands satisfied. In the other prayer, petitioner wanted to direct respond number 1 and 2 authorities to implement and establish the facilities mentioned in communication dated 14/9/2020. Decide communication dated 14/9/2020. Where is that page?
Lords, page 162, annexure F1.
It is 5/9.
No, Lords. But it's 14/9.
5/9.
No, English typing, my lords, I have made a mistake. I'm sorry. My apologies. Annexure of page 160, Kannada shows 14/9, but my
14/9.
my apologies.
Which figures at page whatever 160 into bracket which figures into bracket figuring at page 162. Annexure F1. In the side communication, which is an intergovernmental communication addressed by the Commissioner to the Secretary of the Government, Animal Husbandry and Fisheries Department, stating that since at present there is no permanent office for the Deputy Director, Bengaluru District, and the office is temporarily working from PDDL office. The land of veterinary hospital can be utilized for district office, liquid oxygen plant, district animal medicine go down, armor training centers and such purposes or projects. Full stop. The court is afraid whether an interdepartmental government communication, communication between the governmental authority can provide any cause of action, much less a ground to grant a relief of the writ petition to the petitioner. In that view, the second prayer cannot be granted. The present petition is accordingly disposed.
Obliged.
Grateful. Grateful. My learned friend has saved my task of arguing.
The other two petitions may be delinked, Your Lordship. The other two petitions which is connected to this, that is totally different to this.
Mr. Edgar, interdepartmental contents of the interdepartmental communication does not contain any decision. Cannot be said to be containing any decision. Cannot be said to be a decision.
Yes.
What about the other?
The other two petitions may be delinked, Lordship. That is pertains to the shifting of hospital from Bangalore urban district. That is no way consent to that. May be delinked, Your Lordship. Can be heard separately.
No, dealing can.
Now, in view of the fact that the first aid petition is this.
My lord, I'm filing a memo. My lord, giving particulars of, my lord, addresses with regard to the veterinary sciences. Sir,
What prayer is you are making?
That we have challenged the shifting of the veterinary hospital from Bangalore urban district. 28 hospitals have been shifted from Bangalore to other places.
they've already been shifted, my lord.
No, that is the Lordship's granted interim order that is in still exists. I will go
No,
through this. Your
before the
Lordship.
interim order could be granted, they were shifted. My lord, I'll verify in that case, I'll verify, my lord may have this next week, my lord. Before the
The
granting.
direct judgment of the Supreme Court that the administrative decision of a government of shifting an office cannot be interfered with either in the public interest petition or in a writ jurisdiction. There the question of shifting of a court premises. Direct decision. These prayers cannot be granted, Mr. Yes, you want next.
Yes, I'll try to get that decision and then.
Today she has given me some of the documents. I will go through and I will make a submission.
My lord, I'm placing on memo some of the.
What is this memo?
81.1, my lord. Sorry, my lord, in 81.1, I beg to appear. For the petitioners, my lord.
My lord, the veterinary centers and the details of the livestock within the 4 villages.
Because in the previous writ petition, the government itself has given an undertaking that they will not shift. Within 1 year, they have shifted another 28.
So
Previous to
before that order could have been granted, they've already been shifted, sir.
That so far as 81.1 is concerned, it is in respect of only 4 veterinary centers, my lord. That has not been relocated even as on the date when the interim order was passed.
This I wanted to correct. I wanted to ask. Chalana Desh, Desha. That's movement order. Movement order. Movement order.
What is the illegality in it?
in view of shifting these veterinary hospitals from Bangalore urban district, the farmers who are, as well as the pet animals who are supposed to take the treatment in the requisite hospitals within the Bangalore city, it has been affected. That is the reason they have given an undertaking before dishonorable court in previous writ petition in which we ourselves have filed. They have given an undertaking that they will not going to shift. Within a span of 2 years, they shifted another 28 hospitals. Earlier that they have shifted 38.
How can we enforce it on your behalf?
If your lordship sees the order, the reason for shifting is wherever the cattle's unit is less than 1,300, we are shifting. Even if that is taken into consideration, that is on the basis of National Agriculture Commission report, which says for every 10 years it has been reduced. From 2020, it should be 650. For 650, there must be one veterinarian, even according to them. Now they say that in Bangalore city only for Bangalore city where there is less than 1,300 cattle or animals, then we are shifting the hospital. According to their own census and their report says wherever it is 650, they have to provide one veterinarian.
It is not a statute.
No, it's lordship.
It is not a statute.
I'm not on the point of statute.
And there is no place for
the rights which they accrued for.
There is no place for human beings to live over here in the city today.
That doesn't mean that the animals should also be deprived of their right to have a. That is the reason we have come before the Honorable Court, being the public spirited persons. And it is my organization which I challenged earlier also. They are undertaking by this Honorable, before this Honorable Court, by the government. I request your lordship kindly take annexure F for a moment.
My lord, they can afford to keep pedigree dogs costing, my lord, not less than 50,000, 1 lakh. And they want to depend on the government hospitals, my lord, and pay a minimal amount.
That would have been the stand of the government, that the animals should only
that's-
get in a private hospital. I'm sorry to submit this, your lordship, that will not be deprived for animals. Merely that they are animals, they can afford in the private
I think your trust should be more concerned about spreading awareness amongst people to take care of their aged parents.
Yes.
That is
Aged relatives rather than fostering dogs and cattle within the city limits.
The fund has given facilities, now they are shifting on the basis of this visa. I will go through it and I will come back.
What is the next petition? Another
That's same.
same.
My lord, the same government order has been.
Same government order is challenged. My learned friend in the first writ petition has challenged the shifting of only 4 hospitals, and the organization has challenged the entire government order, which they have shifted 28 hospitals.
so that I can put across to the organization, this is what the stand taken. I will come back to it.
Where is that another 81.2?
Malad, there also the same notification is challenged.
Same notification.
Same notification is challenged.
So
Actually, 81.2 is the main petition, which
writ petition 614 of 24 and writ petition 758 of 24.
In 81.1, I appear.
So you appear in both? No.
he's appearing for 81.
Learned advocate, Mr. So and so for the. And
Malad, there is another connected writ
for
petition.
the respective petitioners in the two petitions filed as public interest. The first petition is filed by the petitioners who are 5 in numbers. The first petitioner is the member of the Karnataka Legislative Assembly from Yelahanka constituency from the year 2008. And the other petitioners have described themselves as agriculturists. Similarly, the other writ petition number 758 of 2024 is by 10 petitioners, wherein the first petitioner is a charitable trust claiming to be advocate for animal rights protection. Full stop. The prayer heard so and so and learned additional government advocates with need of record for the respondent state in both the petitions. And then further continue further. In both the prayers, the identical prayer is made. The petitioners seek to set aside order dated 15/12/2023 passed by respondent number 1, State of Karnataka, Department of number 1, Department of Animal Husbandry, State of Karnataka, whereby it is decided to relocate 4 veterinary centers at Gantigannahalli, Linganahalli, Haniyur, Madapanahalli. It is further prayed to direct the respondents to continue and operate the existing veterinary centers at the said places and not to shift them. Full stop. By very nature of the prayer, they are not liable to be considered in the writ jurisdiction, much less in the public interest jurisdiction. Full stop. Shifting of the veterinary centers from one place to another is purely an administrative decision, which is based on the exigencies found by the executive authorities. Full stop. The court would not substitute its decision, nor would reassess the parameters on which the decision is based. Full stop. Nothing could be demonstrated that the decision is palpably arbitrary or otherwise illegal.
My lord, I'm really sorry to intervene. Really sorry to intervene. My lord, in fact, in my petition, I have placed the records. I'm sorry, I'm appearing through VC also. I should have been there for personal inconvenience. I'm not there. In fact, I have placed the record, which would indicate the department's report itself. Throughout the year, the records have been maintained. That would contradict the grounds what they have cited in the impugned order. It would say as the animal what the number cited in the impugned order is much less than the their own report, my lord. Throughout the year, they have maintained the records.
Learned advocate for the petitioner at this stage submitted that he has produced material on record to justify the prayer for non-shifting. Full stop. The court is afraid whether the court can substitute its view and reconsider the decision. No merit is found in the public interest petition. When the prayers advanced, both are dismissed summarily.
This is number 82 to NR Nayak. Number 82.
What is it about? Any interim order is operated?
No, my lord.
None present on behalf of the appellant. The petition was specially listed at 2:30. Full stop. Instead of dismissing the appeal for want of prosecution, from in larger interest of justice to be listed on 29th April.
Serial number 14 also, my lord. A mention was made in the morning that 14 has to be
Nine
taken up
also.
with it.
The petition, the appeal
Please, my lord.
was called out second time in the second session, then none appeared in same order. Yes.
It has to be
29.
tagged with serial number 82. Serial number 14 has to be tagged.
They will
Because it's the
tag
same
on that.
impugned order.
On that day they will take.
Please,
yes. Next.
43. This is number 43 to KV Narasimhan.
My lords, I'm filing compliance affidavit, my lords.
Yes.
Copy is served. When prior to filing of this contempt petition, my lords, an endorsement has been already been given to the complainant, my lord, but still they have preferred this contempt petition, my lords. Para 10, my lords. Para 9 and 10 of my affidavit, my lords. Page number 4. Page number 4, para 9 and 10 of my affidavits, my lords.
Pass some order.
Please, my lord, we have issued an endorsement, my lord, saying that we are awaiting report from the land acquisition officer, my lords. The complainant, the case of the cannot be considered individually, my lords. There are 6 other members, my lords. The report has to be submitted by the land acquisition officer, my lords. Subsequent to that, it will be considered, my lord. That is an endorsement given on 12/2/2025, annexure R2 of my affidavit, my lords.
Governor advocate. Reducing government advocate, Mr. Raghavendra, health compliance affidavit. Our learned advocate, Mr. Answers, the petitioner wants to take instructions of the client for withdrawal of the petition. Instructions of the petition, 10/2. 22nd April.
Oh, please, my lords.
Still number 44. To Vaishali address. Hearing for complaint.
Lords, we're on the process of compliance, Lords. Tahsildar has written to the ADLR for conducting podium interest.
They
Some-
complied. Kind of. It is same order. Application online. The seller is to direct it to consider the application within 2 months. What is the year?
My lords, this is the Tashildar has written to the ADLR, my lords, to conduct the Podi and Durasti work, my lords. The file is moved.
In process of compliance.
Yes, it is not completed. It is on process.
When you will complete? Within 2
It's
months?
4 weeks, my lords.
Four.
4.
4. They will do, they are doing it. Learned additional government advocate produces on record copy of order dated 13/2/25, which indicates that the process of Podi and Durasti is underway for the purpose of compliance of the directions of learned single judge, post of learned additional advocate, additional government advocate paragraph. Upon being asked, stated that it will take about 4 weeks before the process could be completed. Stand over to 21st April.
Right.
Number 45 to SB Mukanappa.
The last occasions, my lord, the cost has been paid. Only in regarding, only in respect of the arrears of the salary has not been paid.
So what is not paid?
The order passed by the Honorable Court, my lord, page number 30, my lord. Petitioner has been forced to litigate for the 6 months and the management has disobeyed the order to repay to reinstate the petitioner. It would be appropriate to impose the cost of 25,000 rupees within 2 months. In last occasion, my lord, before the Honorable Court, my lord, 25,000 rupees is paid to me, but arrears of the salary has not been paid.
It is the institution has to pay, my lord.
Institution has to pay.
Institution has to pay, my lords, but institution is not a party in this content proceedings, my lords.
Is party. It is a party.
Madam. Sorry, respond number, I'm sorry, my lords, accused number 2 has to pay, my lords.
You are not appearing. for-
Accused number 2.
I'm for respondent.
Last occasions is appeared before
It's a
the Honorable Court
government,
and also paid the.
My lords,
Limb of the government or not?
no, my lords.
No.
This accused number 2 has to pay, my lords.
Public inspection, administration. Who appears?
Not appear, last occasions appeared
Some
and paid the
Srinath
25,000.
P.
Srinath
shown in-
P.
is shown in the cost.
So you joined him by name or not? Manoj Kumar. Not Manoj. Secretary. Same. So he was party to it, Manoj?
Yes,
Kumar, Secretary. This Lakshmi Narsimha,
Yes. Lakshmi Narasimha Education System. Yes,
instead of now Manoj Kumar.
Melody. Secretary is Manoj Kumar.
Ah, How does this? Who is
The Honorable
the Lakshmi Narsimha Vidyas?
with this. The page number 30, Melody, pair number 5, exponent number 4, which has been served and
So
has
wait,
remained.
we'll wait. Let it learned advocate for number. Who is the respondent to implement the order regarding payment of the consequential benefits of salary is not present. Spend over to 19th March to be listed at 2:30. Full stop. Learned advocate for the petitioner shall inform counsel appearing for number 2. Full stop. It is observed that if learned advocate does not remain present on the next date, the court shall proceed to pass in accordance with law.
It's number 46, the Krishnamurthy N.
Respond number 1, minutes.
Lord, on the last date,
That they are filing a review petition. before
They
the
have-
next court.
may I,
Done so.
may I be permitted, my lord, to place these two things on record? Lord, on the last date, we had said that, my lord, a review petition, my lord, has been filed in all the 7 matters before the Honorable Supreme Court seeking review of the earlier order of the Honorable Supreme Court. Lord, the matter is not yet listed. Lord, we have sought for oral hearing also. Open court hearing has been sought. Till now, it has not been listed before the Honorable Supreme. May I be permitted to place these things on record? My lords, my lord, on the last date, I had made a submission that we have filed 7 review petitions seeking review of the orders of the Honorable Supreme Court. My lord, we have sought for open court hearing also insofar as these review petitions are concerned. My lord, these matters, my lord, are yet to be listed before the Honorable Supreme Court. We had moved this matter. Nonetheless, my lord, it is not listed before the Honorable Supreme Court. My lords can accommodate it for some more time, my lord. I can, my lord, this is a case, my lord, where I said, my lord, last time I had made a submission to your lordships that, my lord, this is a case, my lord, where this is an issue pertaining to TDRs, my lord, where few frauds, my lord, have taken place insofar as this TDR issue is concerned, and we have raised certain pleas before Supreme Court also saying that the entire TDR matter, my lord, has frustrated itself.
All this has been considered. and
I
legal
can
order
understand, my
has
lord.
been confirmed by
I
the Supreme
I am not troubling your lordships by redoing or re-arguing the matter before your lordships. What,
You have filed or not?
please, my lord?
Review is filed or not?
It is already filed. I want to place this on record. That is what I'm saying. Sir, Satish, sir. It is filed. It is filed. 7 review petitions have been filed. This is a mail which I have received from my legal cell.
When they are likely to come up?
Lord, we tried to move this matter before the Supreme Court, but my lord, we have sought for open court hearing also because your lordships is aware in Supreme Court, my lord, there is no open court hearing for review petitions. Lord, we have sought for open court hearing also insofar as these review petitions are concerned.
So then you implement subject to the outcome of the.
25/7/23 is a order passed by the Apex Court, you know, and the petition.
Lord, we have sought for certain clarifications. We have sought for certain clarifications, my lord. 4 months' time was.
The court had an occasion to pass the following order on 27/1/25. First of today, after court, today when the petition comes up for consideration, learned advocate Mr. So and so stated that although the review petitions are filed before the Honorable Supreme Court, no order could be obtained. He beseeched.
Please, my lord.
That the BWS beseeched the court that further time may be granted. Also, with the last chance, time is granted up to 15th April.
Please,
Within
much
which-
obliged.
Within which time, unless the orders are obtained in the review applications,
Some concrete decision will be taken in this regard. Within which time?
the
Within 4 to
respondent
15.
shall comply with the
Please.
directions of this court in the order brought under the contempt jurisdiction and furnish to the court the details of the compliance.
Please, please,
On the next date.
please.
Can serial number 69 and 70 also could be tagged along with
This is really the last time.
other matters, madam. Serial number-
69 and 70, my lord, now they have served me the copies. I'll take instructions, the same matters.
You can start along with this matter, sir. Because it is arising of the same, common order.
To be
69
list,
and 70.
to be listed with.
Please.
15, please.
Also, office has raised an objection in that matter, ma'am. Because there's a delay of 138 days because of my affidavit was confirmed on 21/2024, ma'am. And I have filed this, contempt petition in December 2024, ma'am. So it is within time. Ma'am. Office objection is overruled.
To be listed along. So this 46, 46.1, 2, 3, 4, all are connected.
All are connected, my lord. And 79 and 80 also. 69 and 70, I stand corrected.
So all 69, 79 and 60.
69 and 70, ma'am.
16 and 7 to be listed with.
Please. Number 47 for the complainant.
Complaint notice was ordered on 21/1/2025, my lord.
Hmm.
Till today, they have not taken any steps. This are single judge directions to comply the presentation, my lord, within 3 months.
Yes, what you have done?
Sir, I do not have the file, my lords, I'll take instruction. Let's let them serve a copy on me, my lord, sir.
Served, my lord, already served. me. Through process and personally served.
Another copy.
Please, please, start date may be given,
Like,
3rd April.
please.
So number 48. Carving.
Matter may be closed, my lords. They have completed the order. Matter may be
Advocate
closed.
for the petitioners, Mr. So and so states that the order is complied with. The statement is confirmed by learned. Who appears? Learned additional government advocate Srimati Pramodini Kishan. Nothing survives in the paragraph. Contempt petition is disposed of accordingly. Yes, next.
Much obliged.
So number 49, Mr. Sharat has got.
Complaint, my lords. I'm for complaint, my lords.
Little louder.
I'm for complainants, my lords.
Affidavit has already been filed, but I have to file a translated copy of annexures, 2 annexures, my lord. Kindly 2 weeks' time may be
My
granted.
lords, it may be taken up in the next week, my lords. I need to secure instructions, my lords.
Supply is connected.
Yes, my
No.
lord. as
No, my
per-
lords. No, my lords.
Who will verify it?
But I'll take the instructions, my
You have stated that it is connected.
But they have to comply certain conditions.
Please, my lords, I'll need to secure instructions
We
about
have
that.
not complied the conditions, my lord. We are always ready to give connection, in spite
Now
of,
you have passed the order of giving connection.
yes, my lord. We have already
Where is that?
furnished the letters.
Where is that?
Annexure R2.
Where is that letter?
R2, my lord. That is in Kannada. I have to submit a translated copy of
No need. Where is that letter? Tell us.
Annexure R2, my-
Page R2.
page number 14, my lord.
So dated.
Dated 11/2/25, my lord. And immediately after applying for connection, we have issued letter dated 25/1/23. In that letter, we have clearly mentioned that after completion of the work, they have to produce completion work order as well as the chief electrical inspector's report, my lord.
You read in Kannada.
Please, my lords.
What is it?
My lords, that they are telling we have to provide them approved plan and approved,
Approved the granting of connection.
please, my lords. I'll secure instructions about this, my lord.
Monday or Tuesday, my lords.
No, nothing doing.
My lords, one opportunity, my lords. I need to secure.
So it is complied with Mr. Counsel. Where is the question of? As per order dated 25th September 2024, passed by learned single judge. What was directed was to supply. What was directed to respond 1 to 3. ESCOM, full name. Authorities to provide electricity supply to the flats of the petitioners, which were flats number 112, 201, 202. By complying with the requisite formalities for grant of electricity connection. Full stop. Today, when the petition comes up for consideration, figures on record, the compliance affidavit, along with which dated is
11 to
11 to
25.
11 to 20.
Yes.
Figures on record.
Annexure R2.
The letter dated address to petitioner.
Yes, ma'am.
11 to 25, address to the petitioner, which is in Kannada language, and explained to the court to be containing the intimation that the electric supply is approved
Yes.
at the flats of the wherein it is intimated to the petitioner that the electricity will be given to the at the flats of the petitioner upon complying of certain conditions, including the production of
Work completion report
My lords, may I make a
and
sub-
chief electrical
my lords, may I make a
inspector's report.
submission, my lords?
the above letter indicates that the authorities have acted in compliance of the directions of learned single judge. Full stop. The petitioner is bound to comply with the conditions which are prescribed for commencement of electric supply. Nothing survives any further in this contempt proceeding. They are disposed of as not survived.
Machu.
Yes, my lords.
Yes, next.
Case number 50, Mr. B.V. Patil.
Lord, I appear for the appellant, my lord. I seek for an short accommodation, my lord.
No, why?
Lord, I'm inconvenient to senior today, not keeping well.
What is it?
Please, my lord, I represent the respondent. Direction has been given by the learned single judge, my lord, to allot compensatory sites as per the decisions taken by the respondent. When we filed, the order was passed by the learned single judge on 24/3/2023, my lord. 24/3/2023, within an outer limit of 3 months. After we filed contempt petition, my lord, writ appeal has been filed.
So sites are allotted or not allotted? Sites are allotted or not allotted?
No, my lord.
Not allotted. Why?
Not, they say they have filed writ appeal.
My lord. Any day next week, my lord. Senior.
No, any day next week is all right, but why it is not given?
My lord, there is some, my lord, the undertaking is given by the state to allot the site to the land losers, but in judgment is recorded as KDB has given undertaking. That is why we filed writ appeals, my lord. There is an
Appeal is filed. Appeal is filed.
My lord, appeal is filed by the KDB.
Which is that appeal?
The serial number 50, the connected matters.
Both are posted, contempt.
Contempt and appeal both are
Take
listed
up the
today.
appeal. Let us see. Where is the appeal?
First,
On time.
first one, first matter.
493,
You want-
493, writ appeal 493 of 24,
So who is the appellant?
KADB.
KDB.
Where is KID?
My lord, I appear for the appellant in that case, my lord.
Then argue the
My
appeal.
lord, senior will argue next week.
Senior has gone where?
No, my lord, he is not keeping well today.
Not keeping.
Let them, well, at least in the meanwhile, let them take decision to allotment.
At the request of learned record, the appellants, send over to.
Somsekhar team.
No, when shall we keep?
Any date next week, my lord.
26th March.
No, like.
Number 51.
Appearing for proxy counsel.
Kumar.
Appearing for proxy counsel. Appearing for proxy counsel, my lord. The
appearing for proxy counsel. Very good. Anybody said no?
Replying.
My lord, an
Should have
affidavit
to-
has to be filed by the state, my lord. An affidavit has to be filed by the state, my lord. The affidavit is ready. Some translations have to happen, my lord. The matter relates to daily wages, my lord. He attained the age of 60 years and has taken the complete benefit under the Daily Wages Act, my lord. Thereafter, he has sought for regularization of his service and pensionary benefits on par with the government employee. That the learned single judge has rejected the case, my lord, on the ground that he has taken the full benefits under the Act. 2013, he was taken up as daily wages.
It is your appeal?
Pardon me?
Your appeal?
Not my appeal, my lord. I'm defending the case.
So there is nothing in this appeal, Mr.
The original notification was in the year 2014, my lord, wherein the name of the writ petitioner was included as daily wager. He doesn't challenge the notification. Then he attains the age of 60 years, my lord, and then takes the complete benefit under the Act. 5,62,000 was paid to him. Thereafter, a representation came to be filed. That came to be rejected, my lord, on the ground that he has availed the benefit under the Act and not challenge the notification also.
Which notice?
Notification is referred in page number 21, my lord. That is 28/6/2014, whereunder he was included in the roles of the department as the daily wager, my lord. Earlier, he was employed with Karnataka Inland Fisheries Corporation, my lord. Corporation was, the operations were closed and they were brought within the purview of Directorate of Fisheries.
What did he pray for?
Pardon me?
What did he pray for?
Prayer was to give him pensionary benefits on par with the government employees by treating his service as regularized. Initially, he was with Karnataka Inland Fisheries Corporation.
Now retired.
Now retired. 60 years he has attained. He has taken full terminal benefits of.
The petition was filed after retirement.
Please, after that, a representation came to be filed.
After retirement.
After retirement, requesting for regularization. Therefore, learned single judge rightly has dismissed the case, saying that he has taken full benefits under the statute.
Kindly please adjourn, my lord. Senior is not inconvenience.
You are also senior, look like senior, doesn't look. Where your senior has gone?
Inconvenience. He's not feeling well. He's not feeling well. Not feeling well, my lord.
Not feeling well because of this matter.
No.
Let him have his senior.
Much.
Monday? Monday? Monday?
Any date, man.
Any date, Monday, 10th.
Much of it.
52, 53, 54 are urgent. Till number 55. Okay, Vaishali Agde. 55.
Nobody.
Lord, sir, seek for short accommodation.
You are Vaishali Agde.
Appearing on behalf of Vaishali. Senior appears in this matter. Senior counsel appears in this matter.
Then what you people are doing? Why everywhere senior appears?
Lord, he is held up in another court. In other matters, we are appearing this. Senior argument.
It will go then to April 22nd.
Pleasure.
As requested by, stand out to 22nd April as requested on behalf of the petitioners. Like, yes. Hmm.
Fifty-three, my lord, lordships kindly, serial number 53, my lord, it's a state appeal, my lord. So there's seems to be some confusion, my lord, because the court officer says it's adjourned. 53 is a state appeal, notice is yet to be ordered.
Disabled. Disabled.
Correct, disabled.
Number 56.
I represent the respondent number 5 and 6 in this case, my lord. I have filed application, one for dismissal of R5 and one for impleading R10, my lord. I filed 2 applications. The petitioners have to file their objections to my interim applications, my lord.
What she is saying? Very loudly saying, but I can't understand. What is it? Is yes, madam, what you are saying?
I filed an application for impleading
Impediment, actually.
impleading R10, my lord, as Sumeru Realty Private Limited, my lord.
This is
I filed an
PIL.
IE. These are the they are the developers, my lord.
Lord, it pertains to encroachment, my lord. Construction of apartments on Raja Kaluwe and purchase of a lake.
You filed reply?
No, my lord, I'll
File.
file. My lord, steps have to be taken in respect of respondents 7 and 8.
Multi-story apartment, sir?
Yes,
The
apartments.
lake?
Raja Kaluwe, but my lord, one of the religious institution has purchased a government lake,
Purchased. Government lake.
8 acres.
How can lake be purchased?
My lord, that's
That is
done.
what
That
the-
is what the petitioner says. But the prayer is very sad, my lord.
Now the apartment have come up on the lake.
He wants a legal notice to be considered.
Do you appear for the petitioners?
Respondent
I'm
number
for
5.
Whom do you appear for?
I appear for 5 and 6, my lord.
Impleading.
Respondent 5 and 6.
She appears for respondent number 5 and 6.
Number
I have
It is
asked
the
for
heart of
dismissal of
the
respondent number 5 also, my lord. I filed an
It's a Ravi Shankar. Part of lake. You are for number 5.
5. I have sought for dismissal of respondent 5 that I have filed an application, my lord. That's what I said. I made a submission. They have not filed objections to my IES, my lord. He is
My lord,
nowhere concerned.
My lord, I'll seek instructions and make my submission.
Mm-hmm. 23rd April.
Obliged, my lord.
Much obliged, my lord.
Number 58.
Appearing for the
Revisha.
respondent. For the petitioner, my lord. My lord, we have complied with the office objections and have filed the IA for additional documents, my lord.
This is not for office objection. This is for regular hearing. This is for regular hearing, not office objection.
I have some personal inconvenience, my lord.
Your lordship, there is a this petition itself is not maintainable in the light of a PIL, your lordship. On the basis of our inspection reports and our instructions, they are a interested party who are trying to just make submissions and file PIL regarding respondent number 6, your lordship. This cannot be filed in the manner of a PIL, your lordship.
My lord, paragraph 2 of the writ petition, my lords.
Hmm.
Lord, they contend that next to their medical college, there is a poultry farm with 65,000 birds. Because of the dropping of the birds, my lord, there is the farm is not maintained properly, because of which, my lord, the patients who come to the hospital are affected.
And if I may take your lords to page number 44, that's the inspection report of the KSPCB, your lordship. It's the relevant page would be page number 45, your lordship. Serial number 2. Under discussions here, discussions were held with serial number 2. Shri so-and-so, secretary of so-and-so, he informed that they have proposed to establish so-and-so university, which is adjacent to the poultry farm on the western side in an area. They have vested interest in this PIL, your lordship.
Same.
Yes, this is the petitioner. The secretary of the petitioner who has come before this court wants to establish a college next to the poultry farm. And he has said that in our inspection report, your lordship. And now they're seeking that the CFO granted to respondent number 6 is to be cancelled.
So their objections were considered by you.
Your lordship, when we give a CFO to an industry or a farm, we do an inspection and we give. When they came ahead, the secretary of the petitioner trust, he comes and says that he wants to establish a college next to the poultry farm, which is respondent number 6 here, whom we have granted a consent for operation. The prayer in this petition is that consent for operation that we've given respondent number 6 is to be cancelled and revoked by the board.
So that they can establish
Is
a
the-
college there, my lord.
And it's filed as a PIL, your lordship.
It's not a bona fide petition.
My lord, a date may be fixed next week, my lord. Senior address hearing. I kindly request, my lord. I kindly request for a date next week, my lord.
Where all seniors have given today?
Some personal inconvenience, my lord. Any date next week, my lord.
In some camp they have gone. We'll give grant time. When shall we keep, madam?
Any date next week, my lord.
10th of, there is nothing in the, 10th at 2:30.
Yes, your lordship. Great.
Cell number 59. The Ganpati
My
Bhatt.
lord, I appear for petitioners, my lord. I pray for a short accommodation, my lord. I have got some difficulty, my lord, in arguing today.
Yeah. Yeah.
59.
Connect. 58 is called.
58. 58.
59 is called.
No, this is which matter? 59.
59.
59. I am appearing for petitioner, my lord, in 59.
You are not in 59, you are in 59.1, so we'll take up 59 first. It is PIL. For what purpose?
Sorry. Because in the list I saw it is 59.
Lord, this is my lord, water body which is my lord Janikatte.
that has been, my lord, auctioned by that has been granted in favor of Municipal Council Priyapatna. And thereafterwards, my lord, the Deputy Commissioner has passed order to revocation. That last date of hearing, but they have said, my lord, they will file statement of objection before this court. But they have not served on me. Kindly see the annexure A, my lord. Annexure 8, in page number 70 is the translation. That is Karda copy. Karda copy means, my lord, that the Mula, that is original title documents of the government. That is, my lord, Karda. That is first, my lord, after 5 line, my lord, the Janikatte. Janikatte means, my lord, that is reserved for, my lord, cattle, water storage for the cattle, my lord. This is, my lord, the merger. Water sources of reservoirs surrounding lands, water also shows through the canal. When this reservoir was constructed is not known, there is a stilt in the reservoir. The bounds of the reservoir are constructed by mud and it is good shape adjacent to the above mentioned is done. Durasti is not done. Even December water is found. Water is not used by law laying down, but used cattle for drinking purpose. This is, my lord, originally reserved, my lord, for this land is, my lord, Janikatte is called for reserved for, my lord, storage of the water. Kindly see annexure B. Entire annexure B is the, my lord.
This will have to be heard.
Yes, my lord.
Yes,
A grant order of 1964 is sought to be challenged now.
Yes.
And my
I'm
lord may
challenging.
see, the prayer C. He has to go to the civil court
Yes, I'll come to that.
to annul the
Annexure
state deed of
A.
1991.
No, my lord, that they can't submit. Supreme Court has time and then held. Water body cannot be used for construction. Deputy Commissioner has passed order. Kindly see the ink page number, my lord, 247 annexure AA. The Deputy Commissioner has passed order that there is an absolute violation of section 71 and 108, and the grant made in favor of Piriyapatna Municipal Council itself is wrong. And my lord has passed order. Therefore, my lord, it is required for stay. Kindly seeing page number 251. That is translated copy of the Deputy Commissioner order. Appeal questioning the order dated so revocation of the building license in respect of, my lord, the license assessment number 182 Piriyapatna. The Chief Officer Piriyapatna Panchayat had issued a license bearing number so construction of the building in the land bearing Piriyapatna Panchayat assessment number 182 Mysuru. The same was revoked by the Chief Officer on 27/11/2030. Let them kindly. I'll argue, my lord. Since, my lord, kindly see the Deputy Commissioner order. Deputy Commissioner order, please.
Now construction has come up or what?
Objection has not.
No, construction has come up on.
Construction has not come up because
No construction, it has been stopped.
Commenced the construction.
I am appealing with the Piriyapatna
Pillars. I had put
Municipal
up
Council.
See,
That has been stopped.
grant is made in the year 1960.
that has been, my
No,
lord, that has been.
that's a wrong grant, my lord.
Number one.
It's not a
Section-
grant, my lord, it is an
1 minute,
option.
the court is asking some questions here and then don't interrupt the court like this. Grant is made in the year 1964.
For in favor of Municipal Council Piriyapatna.
Whatever.
Yes, my lord.
The sale has taken place in the year 1991.
77. I'm sorry.
1991.
Public
Kindly see.
Public auction was held in the year 1977. It was confirmed by a resolution in the year 1988. Thereafter, sale certificate was registered in the year 1991.
Yes, 1991.
Yes.
You are
yes.
put in possession of the property.
Yes.
Kindly see section 71 of the Land Revenue Act, when there are certain procedure prescribed, if at all, my lord, granting the land in favor of, my lord.
How many years up? He has been in enjoyment of the
No,
property
he
since
is not in enjoyment of the property. My lord, this has been granted in the year of 1960. This is a water body. Absolutely, there is no issue regarding that. Section 71.
Majestic bus stand.
May- my-
Majestic bus stand
No.
was known as Kempambudi Kere.
Yes, my lord.
Now you file a writ petition if you allow
No,
this
no,
writ
no.
petition.
Here, there is no building has been come up. Let them come. Kindly see the Deputy Commissioner order for a moment, my lord. Kindly see the Deputy Commissioner order. And my lord, that I'll produce, my lord, the Supreme Court recent decision also, water body.
Sir, Majestic bus stand was a lake. Your Country River Stadium was a lake.
But
Your Kormangla village
but
complex.
that
What is
nobody-
that game? Where our judges reside, no?
I agree with that. Provided, my lord, kindly see the
Adugudi.
ink page number 251.
It was a lake, so we need to demolish all these things and if this logic is applied.
My lord, my respectful submission is they have not started construction. There is an order from the Deputy Commissioner. For a moment, I'll draw your lordship's attention. This is water body, reserve for cattle. Majestic, yes, my lord, I agree. That has not been challenged come before this court. This is, my lord, village area. This grant has been made in the year of 1964 Municipal Council itself is wrong. Deputy Commissioner has passed order saying that this is violation of the section 70 and 108 of the Land Revenue Act. And thereafterwards, my lord, that the Deputy Commissioner has taken into consideration and passed order and license has been revoked. If at all construction by violating the revocation of license which is granted, kindly for a moment turn in page number 251 for a moment. And Supreme Court has held that I will demonstrate before this honorable court if they are filing objections with photographs, let them produce. Otherwise, I'll produce photographs also. Kindly see the order at ink page number 251. That is dated 2/8/2017. Translated copy. Got it, my lord? 251, my lord. Translated copy. Can I read, my lord, in para 252? The appellant has filed appeal through council on 7/12/2013 and contended that 1 acre 23 guntas in survey number 123 bar Piriyapatna town was auctioned eastward Piriyapatna municipality. The appellant's father, Syed Abbas, was the final bidder for the bid amount of rupees 5030 and same has been remitted to the municipality. On 1988, registered sale deed executed by the Panchayat secretary in area measuring east to west 201 feet and north to south 253 feet. Hakkupatra was issued, position was given mentioning Panchayat assessment number 505. On the request of municipal members and officers, 201 into 253 feet was relinquished for a road. Due to this, the site size changed into 94 into 253 and 80 into 53 and 80 into 140 feet. This property was gifted by appellant's father to the appellants through registered gift deed dated 27/6/2013. Kata has been changed. Tax has been paid. The property is being enjoyed since causing obstruction to anyone. For construction of the on-site site, the license requested for the respondent documents were submitted. Engineer have inspected spot and based on the report, building plan was approved on 21/9/2023 and license was issued. After obtaining building construction has been commenced and is in progress on the basis of the application submitted by N. Ravi. Yadavachar, case was registered in Tahsildar Court in LNP CR 94 of 2013 and 14, and notice were issued to the parties. The respondent directed to cancellation of the license issued to the appellant. The respondent sends examination and since holding inquiry has passed order on 27/11/2013, cancelling the building license issued under section 188 of Municipality Act and ordered that the building work be stopped. Since the sense any intimation revocation of license is illegal, order is not sustainable. The appellant constructing the building as per license so and so dated 21/9/2013, and if construction is stopped, irreparable loss will be caused. Appeal is filed for revocation of order of stay of license. N. Ravi Kumar Yadavachar have filed application under section 1 and rule 10 read with section 1 CPC, praying that they are read as a respondent in the above appeal. The application is examined. It is found that the rules mentioned in the application is applicable only civil litigation. There is no personal interest in the proposed land, and to decide the case in their presence is not essential. If the property is a government property, then application can be filed before the competent under appropriate rules. Hence, the application dismissed on so and so. The document submitted by the appellants and respondent examined pursuant to the order DSR PIR 8/72/73/56 of 63 dated 2/5/1960. The name of the erstwhile Piriyapatna Municipal is mentioned in RTC in respect of 1 acre 7 guntas in survey number 123/2 of Piriyapatna. After municipality, it is changed the panchayat as per resolution number 8 dated 3/6/1988. General meeting 1 acre 7 guntas in survey number 123 has been settled by way of auction in favor of the appellants. Further, Syed Abbas for rupees 503G. After remittance of the amount, proposal was sent to Jilla Panchayat registering Khata in the name of the bidder and approving auction. This was examined Jilla Panchayat Mysore Ward official memorandum. Date in para page 256, my lord, clearly hold that this is reserved for my lord. 256 para may kindly be seen for the Deputy Commissioner order. Survey number 123/2 measuring 1 acre 7 meters government Karab land reserved for Janikatte under section 17 of the Karnataka Land Revenue 96 to grant B Karab land to Piriyapatna municipality. B Karab land has been cancelled by the state. Thereafter, grant should be done by the government. In this regard, respondent has not submitted documents to Khata is illegal. As per the revenue village map and Khatewar Priyapatna survey number 123 is a reservoir, cannot be granted for other purpose. To alienate the land by way of auction, approval has to be obtained from the competent authority. Thereafter, approval has to be obtained, council for notification has to be made in local newspaper, and proceedings have to be conducted. No kind of rule has been followed. Syed Abbas bid of rupees 5030 is considered as final bid. Money collected over a period of 2 years, and registration is done before Sub-Registrar Piriyapatna on 28/8/1991. Thereafter, municipality has mentioned Khata number 188. Through gift deed, Khata has been transferred in favor of so and so, so and so. The observation reserved from the public, and since the case is registered Tahsildar office regarding title over the land, but Patna Panchayat has on 27/11/2000 stayed the execution of operation of license. In respect of this land, my lord, ultimately, my lord, license has been cancelled. My lord, they have once license issued, my lord, that litigation started. Therefore, my lord, this is, my lord, clearly hold that while granting the land in the year of 1964, procedure has not been followed. And thereafterwards, my lord, the grant should not be made in the municipal council for formation of site without procedure, following the procedure. And this is admittedly water body. And now, my lord, they are constructing. Under those circumstances, my lord, in case, my lord, that whatever amount, my lord, municipal council, this has to be reserved for, my lord, this is water body. Under those circumstances, Deputy Commissioner has passed order. The Honorable Supreme Court, my lord, has time, water body cannot be utilized for construction of the building. Therefore, my respectful submission before this Honorable Court, admittedly, my lord, all the documents which we have produced, this is a water body and this is reserved for cattle. And Section 71 has not been followed. And license has been cancelled, which, my lord, that they have approached this Honorable Court. Litigation is pending consideration before the learned single judge for order passed by the Deputy Commissioner has been challenged. Under those circumstances, my lord, the government has to come before this Honorable Court clearly that whether we have made all of them party, let them file objection before this court, stating that they are entitled to, my lord, construct a building in a water body.
Is challenged in my lord 59.2.
Now, what is your stand?
My lord, that I'll have to seek instructions.
Let them file objection before this court, my lord, narrating. If I am wrong, my lord, that I have no case. If this is, my lord, fought from 2012.
One important aspect is the property has been made over to Piriyapatnam municipality even before the commencement of Land Revenue Act. Annexure A is dated 6/11/1963. Land Revenue Act has commenced from the year 1964. Before that, this has happened. And now the water body has not retained its character as a water body. The road has been formed by the municipality itself. Some portion has been gifted to some Takwa charitable trust. In the remaining portion, he wanted to construct a school. When he started the construction, then this very same petitioners obstructed.
So in the records, it is not known as water body.
But in the year 1977, but after
Now in the records, the land is shown as water body.
no, my lord.
Show that.
Long back, Piriyapatnam municipality itself called for public auction, saying that this property belongs to the municipality. Interested persons can bid.
Then it is on record, all these things.
It is there in the records.
Road is also late.
My lord?
There is now road passing.
Yes, there is a road.
Now, some portion of the land has been, my lord, that some portion road has been formed.
Where from can we get the
But
details?
in the deputy commissioner's order itself, it is record 252. Page 252. Last paragraph. On the request of the municipality members and officers, 201 into 253 feet was relinquished for road. Due to this, site size changed to 94 into 253 and 80 into 53 and 80 into 140.
Copy there.
Now, building plans are approved in your favor
Yes, ma'am.
into 13.
13.
Nothing has happened.
That has been cancelled.
We have erected a pillars during that time, these
They have cancelled.
proceedings.
Cancelled by virtue of a deputy commissioner order. It is cancelled, my lord. Therefore, I have read that. (251) is, my lord, deputy commissioner orders, saying that all illegal grant has been made, my lord, respective page, my lord, 256, my lord. last para which clearly stipulates that. Kindly see the,
Yes, should have been molded accordingly.
admittedly, my lord, all documents which you have produced to annexure A to D is showing that it is a water body. My lord, the Supreme Court has, my lord,
Because of the order of Deputy Commissioner, you are not in a position to take a stand.
My lord, the prayers should have been molded accordingly, my lord, looking into the order of the Deputy Commissioner. My lord may see the prayers, my lord, that has been sought.
No, not just that, in the other two writ petition, they challenge.
Yes, I can. I cannot.
That's the problem.
and that water body showing that I have produced all the.
Then road also should not be there, sir.
Please
In the
follow.
lake, you can't form a road. You have to form a bridge.
That is what.
Yeah?
That is also, therefore, my lord, we have sought, my lord, entire extent. Supreme Court, my lord, recently hold that water body cannot be at all to any purpose. That is your lordship is aware. Even though majestic. Khata also has been cancelled. License has been cancelled.
Who is this Sayyid?
Please, my lord. This, my lord, you are appearing?
I'm for respond number 7.
Who is
Sayyid
that?
Mateen Abbas.
Sayyid Abbas. Who is that?
Father's name is Sayyid Abbas.
Your
Yes, my lord.
Mask. License has been restriction for mask.
sorry, dismissed.
Kindly see, Supreme Court has sent, my lord,
We'll
kindly
deal
for
with
a moment.
Sorry.
And
Other two we are segregating.
my lord,
Oh.
kindly see the
Court as per the roster.
page 8, my lord,
Page 8.
page 8.
The copy.
Para 16, my lord, starts. The present case, the land records as village font, the court is on Hinchlal Tiwari versus Kamala Devi AR 2001 SC 3251, followed by the Madras High Court in L. Krishna versus State of Tamil Nadu, held that the recorded as pond must not be allowed to be allotted to any for construction of house or any allied purposes. The court ordered the respondents to vacate the land that they had illegally occupied after taking away the materials of the house. We passed similar order in this case. In this connection, we wish to say that our ancestors were not fooled. They knew that in certain years there may be droughts or water shortage for some other reasons, and water was also required for cattle to drink and bath in etc. Hence, they built a pond attached to every village and tank attached to every temple, etc. These were their traditional rainwater harvesting methods, which reserved for thousands of years. Then, my lord, ultimately in 18, over the last few decades, however, most of these ponds in our country have been filled with earth and built upon the greedy people, thus destroy their original character. This has been contributed to the water shortage in the country. Also, many ponds are auctioned off that throwaway prices to businessmen for fisheries in collection with authorities, Gram Panchayat officials, and even this money collected from these so-called auctions are not used for common benefit of the villagers, but misappropriation by certain individuals. The time has come when this malpractice must stop. My lord, Supreme Court has another two decisions also hold that water body, if the any water body
Here, the persons who are illegal occupants. You come to-
maybe, but we have established and Deputy Commissioner has considered that the grant made in allotted.
Deputy Commissioner has not passed the order based on the current situation of the land. He has considered the revenue records and has come to the conclusion it was considered as a pond prior to making of the allotment. And he says the sale is bad, which happened way back in the year 1964.
Kindly see, my lord, 115 page for a moment. This is grant certificate under Parisista Jati. That is, my lord, SC grants in the year of 1964. Kindly for a moment see the grant certificate in favor of municipal council, which is under SC category. The translated copy may kindly be seen. This grant is made in page number 123 is translation copy. This is under Form 1, Grant Certificate of Revenue E-Schedule. That is Parisista. This grant has been made in favor of municipal council, which is also not permitted. And thereafterwards, my lord, after this grant for formation of site has not been formed. This is in the year of 1988 auction. Till now, the water body, my lord, is there, but now they have started construction. Therefore, Supreme Court time and then hold that, my lord, the water body, if it is, my lord, clearly this grant itself, and in page number 123 is SC grant. The municipal council cannot become an SC. Therefore, Deputy Commissioner has passed order holding that this grant itself is wrong. That is not, my lord, under section 71 or 108. This the water body status has not been revenue status, and the original status of the land has not been taken back, and there is no such order passed. And this is an SC grant. Under those circumstances, my lord, grant. If at all, my lord, they are constructing building, yes, my lord, no, it is not constructed. Under those circumstances, my lord, there are other judgments also there. Supreme Court, I'll make all the list and file synopsis, if at all your lordship can consider.
Sorry, after 35 years, you are not going to examine.
No, no,
That too in a-
I'll produce another
too in a public
two
interest.
decisions, my lord, because this is, we have fought for about 14 years to safeguard this property. 14 years that we have fought. And admittedly, it is a water body. Kindly see another two decisions of in that other compilation also, that page 13. That is 2021 Supreme Court 3215. Allotments of challenging as a ground that the allotment of land form part of fund. If at all any allotment made, my lord, for the fund, then, my lord, that has any in such facts, no part it could have been allotted anybody for the construction of the house building or allied purpose, allotted directed to vacate the sites. My lord, ultimately, my lord, the Supreme Court has said that the pond cannot be utilized for water body, cannot be utilized. Then, my lord, ultimate the year 2005 Madras also clearly hold that water body cannot be utilized. I have produced many number of documents to show that, my lord, this is a water body.
That's all. We'll deal with all judgments, yes.
Please, my lord.
So 3 judgments you have cited, we'll deal with. Dismissed.
I may be permitted to, my lord, implead in, my lord.
They will go to the other two, which is the other 59-1 and 59-2. 59-1, read petition 2, 3, 5, 4, 6, 16. So this petition was connected to read petition number 11, 9 was listed, treating it as connected with read petition number 11, 975, 24. The said read petition is dismissed by order of given date. Full stop. The subject matter of the present petition paragraph is required to be dealt with by the honorable bench taking up such matters. Therefore, it shall be now segregated and shall be listed before the appropriate court as per the prevalent roster. Same order in 59-2. Identical. Yes.
Number 60. Grish Kumar.
Lords, this matter, we have complied the order, my lords. Compliance affidavit has been, memo has been filed, my lords, for compliance.
It's complaint, madam.
Learned advocate for the petitioner as well as learned additional government advocate. Petitioner so and so, as well as learned additional government.
Lords, there's
Both stated that the order under contempt is complied with. In that view, nothing survives in the present contempt petition. It is disposed of as not surviving.
Lords, I may be permitted to take notice for respondent number 3 KEA also, because I took instructions, my lords, that the fine also has been paid, my lords.
You said complied with.
It's complied, my lords. I may be also permitted to take notice for respondent number 3 KEA, my lords. Part of the order has to be complied by KEA. That has been complied.
It is stated by learned additional government advocate.
No,
Part of the-
my individual name has to be Pramodini Kish.
So what do you want? Not to be disposed of today?
No, my lords, disposed of. Only notice is not issued to KEA, my lords. I will take notice.
Which a notice,
I am on the panel of KEA also,
notice to the respondent KEA.
please.
Full stop. Learned additional government, learned advocate, Mr. Modification appears and accept notice.
Please,
Then send the order.
oblige. Oblige.
It's number 61.
61, my lord, the service is not complete, my lord. We'll take the needful action.
So madam, we wish you double benefit. We wish you double benefit.
1+1.
Yes,
But
in the earlier.
61.
Nothing wrong. Just in lighter way, yes.
The panel, my lord, so I submitted.
Yes, no, this is all in lighter way. Don't take anything serious. What is, nothing serious in it. Yes. Yes, next.
61 service is awaited, my lord. Service is awaited, my lord. Notice has been.
Service is awaited to be listed, since service is awaited to be listed on 17th April.
Yes.
62 dispose, number 63. There are steps. Taken steps on the last hearing date. Our service is awaited, my lordship. We will take fresh steps.
Yes, it is to stated that the service from the respondents are awaited. Therefore, it shall be listed next on 24th of April. So 64,
Number 64.
64,
Office
65,
objection with-
66. 67. In all matters, identical order, separate order. 4 weeks' time is granted to remove the office objections, failing which the petition for appeal is the case made. Shall stand disposed of, shall stand dismissed automatically without reference to or order of the court. 4 weeks. 10th time. Is not of that. So up to 66 only. Give 3 weeks time, not 4 weeks. 5th time. No,
Number
67.
67.
Yes.
Lord, 67. Lord, I am for the appellant in writ appeal number 1282 of 23.
Hmm.
Lord, the only office objection was to serve the cavator copy, my lord, which was served through email. Lord, therefore, my lord, on 10 to, my lord, the order was a preemptory order. This caveat copy is served, my lord, appeal may be taken for hearing.
It was stated by learned advocate Mr. So and so that the copy of the appeal is already served to the counsel for the learned
Then
counsel caveator.
Then
In that view, that being the
1282.
only office objection, the appeal is required to be posted for admission hearing. Full stop. In view of the statement made as above, the appeal shall be listed by the registry for admission hearing on when? 2nd April?
any date.
2nd April.
Grateful.
This is number 68. Office objection with counsel petition.
I am for the complainant in this matter, my lord.
Hmm.
My lord, the only office objection that has been raised in this particular petition is as to why accused number 2 and 3 have been made parties, though they are not parties in the writ petition that has been filed by me, which is numbered 19807 of 2024.
So direction is issued. Anyway, for the time being, office objection is complied with, subject to examination of the office objections at the time of hearing. The contempt petition may be listed on 3rd April.
My lord, please see the, my lord, interim order, my lord. The prayer is for the interim order dated 26/7/2024, non-compliance. My lord, at page 36, my lord, the last paragraph.
Which?
Oh, my lord has adjourned it.
No,
I'm
we
sorry,
have-
my lord,
we have
68.
said 68.
My lord has adjourned it. It's
We have-
adjourned.
No, we have said that the office objection is dispensed with to be listed on
My lord, the date is, my lord.
2nd April.
Number 69, 70 are adjourned. Number 71. Office objection with counsel submission. Kiran B.
Current in this case, my lord. The office objection is to provide a
Copy.
memorandum of petition filed in writ petition 19835 of 2024. That is filed by some other person. My lord, it is since it is a we are challenging this order. It is a PIL matter, my lord. The honorable court has restrained several mining license holders to stop the illegal mining activities in the vicinity of the 20 kilometers of the KRS dam, my lord.
Pending removal of his pending removal of his objections, contempt petition shall be listed on 3rd April. 3rd April.
Maybe listed with the PIL matter itself, my lord, since the
Why?
matter. It is on 5th June, my lord, I think. 5th June. The main petition is listed on 5th June, my lord.
You are saying that the office objection is about non-production of the copy of this PIL.
Yes, my lord. It's a PIL concerning to the KRS dam, my lord, whereas I am challenging that the respondent number 1, he is a license holder, he is violating the interim order of this honorable passed in that PIL, my lord.
You see, you must have produced the interim order.
I have
in your-
produced it, my lord.
Then where
Interim
is the question of listing the PIL? Then both may go together if you want to be listed with the present contempt petition arise from the order passed in writ petition number 1983/5/23. It was stated by learned advocate Mr. So and so that the main petition is coming upon 6th June. Accordingly, this contempt petition shall also be listed along with the said petition on 6th June. Shall by 6.
Number 72.
The complainant, my lords. This objection is with respect
Office
to why,
objection is dispensed with.
Please.
Contempt petition shall be listed on
Lord, very short matter.
27th of March.
Great.
73 is urgent. So final hearing matter, seal number 74. A. Nagarajappa.
Hearing petitioner, my lord. There was some emergency to the senior, my lord.
What is it about?
Kindly pray for a week of time. Kindly pray for 2 weeks of time.
What is it about?
Sir?
What is the subject matter?
No?
Two 2011.
Yes.
We will not post it beyond 12th of
Obliged.
March to be listed at 2:30.
Petition in serial number 71, my lord. It is 5th June, my lord. 71, it is 5th June, my lord. June 5.
5th June.
Number 75. The GR move.
Here for the petitioner. This matter pertain to the collection of toll under national highways, wherein there is a Central Road Fund Act is there. By virtue of that, we pay diesel cess and also petrol cess, and there are thousands of tolls are involved. In the meanwhile, now I filed an IA1 of 25, your lordship. Whereas when the collection of tolls, the period, concession period is already over, but still they are collecting. The document in the state, within Karnataka state, IA, your lordship, 1st February 2025, your lordship, IA1 of 25. And the matter was pending. IA1 of 25, your lordship, is filed on 1st February, in which your lordship may kindly see. There is a fee amendment also happened in 2013 rules, your lordship. Then thereafter, the list your lordship will see, in several places period is already over, which is the reply given in the assembly for how they are collecting toll plazas. Then your lordship may kindly see the page number 9, your lordship, Z1, page number Z1. There are already end date, your lordship, first one. Bangalore Nirmala Toll Plaza 24/2/2024, end date, you like. Page number 9, you like. Then similarly, 3/8/1/2020 end date. Then again, Sri Sai Enterprises 17/2/2024, Nellore. Then 16/3/2025, 8 item. Then again, 9, serial number 9, 10. Then thereafter, there are several places where the term has expired, still they're collecting. For that, your lordship may kindly see, I may be permitted to pass on the judgment of the Honorable Supreme Court in Noida Toll Bridge Plaza, your lordship, wherein when the term is end, they can't collect the fees. Noida Toll Plaza, your lordship.
You will take up after. This is
And
required.
also one more thing, your lordship, there are two judgments I want.
Give judgment.
May I request your lordship, I'll pass on this judgment also. And latest Jammu and Kashmir judgment also is there.
Okay.
This also, your lordship. Jammu and Kashmir, where, because the example is that when the terms are all over, they can't collect the tolls, your lordship. And also there is a direction, your lordship, but at the end, it is a violation of Article 14 of the Constitution read with so and so. That contravenes the public policy and is therefore liable to be served severe from the agreement. So the court has also opined how it should be done and what is the steps, direction, and also another direction is given by the Jammu and Kashmir High Court, the latest judgment, your lordship. May pass on this. In the latest judgment, your lordship may see there. In that, the several directions were given. These are dated 25th February 2025. Your lordship will find at paragraph 18, your lordship. Several directions were given when the, as per the two, now earlier this Jammu and Kashmir High Court was able to refer only 2008 rules, your lordship. Now 2013 rules have been amended now. By virtue of that, how the National Highway should collect tolls, incomplete roads, like your lordship, I have filed a earlier memo that Shirur, where the deaths have taken place, landslide, the road was incomplete. They allowed the vehicle to pass through and collected tolls. So these are the issues where they should be. Paragraph 18, your lordship.
Yes. You'll take up on some other.
Yes.
Yes.
Because if your lordship look into the details which are furnished under the Central Road Fund Act, there are thousands of crores. That is, your lordship will find it annexure for a moment. Annexure. Annexure N onwards, your lordship. Annexure N onwards, page 91. Given all the figures which is furnished by the Director General of Systems and Data Management, Central Board of Indirect Taxes and Customs, wherein how the amounts have been collected and for the Central Road Fund Act. So our main issue is that when Central Road Fund Act is placed in force in 2000, there cannot be another under the 1995 Highway Act, which is amended in 95. This court wanted to know whether the object of the act. I produced the object of the act also of the Central Road Fund Act as well as the amendment of the. So this is the issue, like.
But you have produced only 3 judgments.
Yes. Pardon?
Only 3 judgments you have.
Yes, sir.
Why don't you give 30? Some more judgments.
Please.
On next. By the next day, you find out some more.
Now, because this matter is pending for the past 5 years.
We don't want only 3.
For
We don't want only 3 judgments. We want you to cite more judgments. When shall we?
Please.
Next week.
Next. And my response submission, the IA may be listed because the
IA or
main
IA.
issue is about the IA, where even now they're collecting tolls. It will be listed in the hearing on IA so that the matter can be
With IA to
can be listed. There are 2 applications pending. One for direction 2013 rules is there. The Jammu and Kashmir court refers to the 2008 rules. Now 2013 rules have been. So that the petition can be disposed of.
Central government.
Yeah.
See, Mr. Shanti Bhushan is appearing. Probably you can, you and National Highway authorities can answer it. See, couple of things where the period is already over.
So
It is found that tolls
still they are
being-
collecting the tolls. That's what submission of
Number
chair.
one. Not only that, practically also speaking. Number two, the road will be under repair.
True.
See, you collect the toll because the vehicles can
Smooth road is there.
move properly
True.
without any problem.
Okay.
Can you collect the toll when the road is under repair?
Repair. Got
Yes, they may lay the road, the vehicles may be plying, but after some time, the road comes under repair.
True.
Okay, at that time, what happens? Half the road is blocked, the other half is not proper, there'll be potholes and other things. They'll be maintaining the other side of the road, tarring it.
True that.
Still, you will be collecting the tolls.
That is
How
permissible.
it is justified?
Got it, Manoj. Because
And this is a case wherein the individual vehicle owner, though he feels cheated, fleeced, he is not in a position to take legal
Expose.
recourse because for 100 rupees he can't fight.
I got it, Manoj.
Okay. And you should also come out with a policy like what is the amount per kilometer you are going to charge.
What is the basis on which it is being fixed and what can
Because
be
outskirts, we have a road, probably it's the highest toll road in whole of India.
true, Manoj. If we take example of airport road itself, so number of vehicles passing through that toll plaza is numbering. And what is the cost involved to construct that road? How it is monetized and how it is being refunded? That I got it, Manoj. Try to get the information and try to place it on the
See,
card.
No,
Got it, Manoj.
many people, they have this heartburn
True, Manoj.
when they
Pass
pay
through
the
the
money at the tolls.
True, Manoj. Every common.
Sometimes the cost of an SUV is much more than 50% of what you pay. Of
Sure.
course, we don't pay anything, that's different. But private individuals,
True, Manoj. Number of trips he makes in a particular road, the cost of
no,
total.
no, SUV, more than 50% of the cost is tax component.
Task. True, Manoj.
You have tax component like above 4 meters. The ground clearance is more than this much.
Based on designs. I got it.
So when that is the case. Yes. Okay, so yes. Fortunate for that. More than 50% cost, we go towards the tax.
That is luxury cars, a segment. And different.
I will pass on the judgment to him, Your Lordship, so that Jammu and Kashmir, what suggested is all reflected in the judgment, Your Lordship. Mr. Madhukar Deshpande used to appear, he has not filed his wakalat, basically. And another aspect, Your Lordship, yesterday onward, there is a notification, this electronic flyover is there, Your Lordship. That road has become in a bad shape now. They are closed for night traffic now. But day traffic, they are allowing from today onward for until further order. Till the road is night, they want to repair and maintenance, they want to take up. So
Similar
this
way,
is how
But you should have a policy that when part of the road is under repair, that stretch you cannot charge.
Correct.
Something like that.
2 minutes. Because every time there some portion of the road will be under one or other inconvenience for the
That's
users.
the reason.
Especially city limits is the most
In fact,
repair portion.
Honorable Minister, MRT has mentioned that is reflected in the judgment of Jammu and Kashmir, that where there is roads are in bad shape and things, you will not collect toll. That's what that is all recorded in the Jammu and Kashmir judgment also, basically.
paragraph 86 CAG report says something. I think that requires little more further modifications in terms of fixing the fee. Initially capital investment and continued maintenance part. How much can be fixed, charged also may be required. This CAG report says so.
But in an appeal, another appeal filed by the NHI, the Honorable High Court in July 24 has observed when incomplete and you cannot collect toll. That is the direction is given also. May I pass on, because I have only one copy right now, I'm able to download. Tell the number. Okay. Last paragraph. They also want to know what is the definition for what purpose NHA stands for, what for. The National Highway they say authority, what is their role? That's what the Honorable Supreme Court has observed in this matter.
We'll take up, please, with some detail.
There's one more aspect in that petition, what we say. They collect the road tax, lifetime tax they collect. That also will go to the road fund, basically. And they all should be used part of it. That is also not happening, basically. That is also one of the issues we raised in this.
Fourth capital.
Number 76. Tajay Kumar Patil, party in person. For final hearing.
Your Lordship, I appear for the petition in the connected matter, my Lord.
Connected all right, but main matter, who is appearing?
My lord, I appear for the seventh respondent, my lords. I have entered appearance in the matter. My lords, a short accommodation may be granted to me to file my statement of objections, my lords, to the matter.
Number 77. Suresh Babu.
Serial number 77, my lords, the BDA may have to file a response. The limited prayer, my lords, that the public interest petitioner has made is this, my lords, that the sixth respondent society had executed a relinquishment deed wherein the BDA was supposed to take possession of those sites and maintain them as civic amenity sites. Now, admittedly, my lord, 16 years later, that has not been done. There is a correspondence which has been produced along with our petition, my lords, pursuant to a contempt that we had filed. So it may be necessary for the BDA to take take a stand on oath.
Short accommodation, my lord, sir.
They are parts relinquished by urban.
By the sixth respondent, the society, my lords, and society, land was acquired for the benefit of the society. Now the land was handed over to the society, relinquished, a certain amount of the land had to be relinquished to be maintained as parks and open spaces. Now the relinquishment deed was executed. But my lords, I think what happened in the middle is there were some illegal encroachments, which after the relinquishment deed was executed, it was the responsibility of the BDA to ensure that they were removed and possession was taken. Now the laxity in doing that, my lords, is what the public interest petitioner's grievance is.
It's a short accommodation, my lords. I've submitted my statement of objections, my lords. I'm waiting approval, my lords. 2 weeks accommodation, if I may request.
But then in this it's an issue to be gone into in public interest. Answer it,
please. I should do that, my lords.
This relinquished deed was on 2009. Nothing is happened.
Nothing is happened. Now, in fact, after we filed an earlier round of litigation, my lords,
within the city area.
This is, my lords, exactly where it is, my lords, is after the Hebbal flyover on the left-hand side. There's an area called Sakar Nagar. On the other side of the railway track is where this locality falls.
So near that GKVK.
So now all land must be open and encroached.
Yes, no, that's tremendous number of encroachments have and admittedly happened. In fact, there's a correspondence between the society and the BDA also where they say that that land is not available. It's been developed. Now, whatever that can be salvaged is what this, he's a resident of that locality, the petitioners.
That's my information is that 60% alone of the sites have been relinquished to the society, my lords, because of they not been able to, maintain the parks and the sea amenities, my lords. The 40% is still retained by the BDA, not
We are only concerned with the relinquished part.
That's all.
Please. Yes, I shall answer.
And in respect of it, your responsibility lies.
Yes.
To develop.
Please.
And monitor.
Correct.
And to see that it is not
Encroachment.
wasted by encroachment.
Please.
So I'll reply
Please, I shall.
on behalf of the
Development Authority. BDA.
Third respond.
your
Third-
VDA.
Third respond.
VDA, it was stated that the reply shall be filed before the next date, put up on 20.
Sometime next month, if I may request, my lords, on April
Month.
1st or 2nd week. my lords.
Next month.
My lords, I appear for respondent number 6 in this matter.
Yes,
I'm sorry, my lords, I was not present when the matter was called. I filed my statement of objections. I've also paid the cost, my lords.
this one, this matter.
Please, my lords, in serial number
Society-
77.
Society is.
So we'll
Society
continue
Grievances with
on
the
7th of April.
Great, great.